working?
Mike's on.
Mic on? There we go. I'd like to call to order this regular meeting of the Lincoln Lancaster County Planning Commission of November 30th. This is 9th.
Oh, sorry.
A printed agenda is available outside the hearing room, and a copy of the full agenda, including staff reports, is available at the front of the chambers with the clerk. The Open Meetings Act is posted just inside the door at the back of the room. If you parked in the parking garage across the street to the north, please be sure to pick up a parking coupon on your way out. They're up here with David. Out of courtesy for those attending this meeting, the commissioners and the staff, cellular phone usage is not permitted in these chambers during any portion of this meeting, and we appreciate your cooperation. At this time, I would like to welcome a new Planning Commission member, Sandra Washington, who is participating in her first meeting today. Sandra's right over here. Sandra was appointed to fill the seat previously occupied by Kathy Beecham. Welcome, Sandra.
Thank you.
Please note the Planning Commission action today is final on the following items. Number 1.4, preliminary plat, number 16006, number 5.2, county special permit number 16049, and number 6.3C, use permit number 16009. Any aggrieved person may appeal final action of the Planning Commission to the City Council or County Board by filing a notice of appeal with the respective clerk. Appeals to the City Council must be made within 14 days of Planning Commission's action, and appeals to the County Board must be made within 7 days of the Planning Commission action. The Planning Commission action on all other items is a recommendation to the City Council or the County Board. The first item of business is the approval of the minutes of the regular meeting held November 9th, 2016 as revised. May I have a motion?
Move approval.
Second, Harris.
Jerry, please call the vote.
Cornelius?
Yes.
Core?
Yes.
Harris?
Yes.
Lust?
Yes.
Sunderman?
Abstain.
Oops. Washington?
Yes.
Weber?
Yes.
Shear?
Yes.
Hove.
Yes.
Motion carried 8-0 with one abstention.
We also need to approve the minutes of the special hearing held on November 16th, 2016, relating to the 2040 Comprehensive Plan and Long Range Transportation Plan updates. May I have a motion for that?
Move approval, Cornelius.
Second, Weber.
Thank you. Jerry, please call the vote.
Cornelius?
Yes.
Core?
Abstain.
Harris?
Yes.
Lust?
Yes.
Sunderman?
Yes.
Washington?
Yes.
Weber?
Yes.
Shear?
Yes.
Hove.
Yes.
Motion carried 8-0 with one abstention.
The next item of business is the consent agenda. Items on the consent agenda will be called at the same time and will not be scheduled for a separate public hearing unless there is a request from someone wishing to speak or at the request of a commission member. I will ask Jerry to read all the consent agenda items into the record. Once those items are read, she will ask if there is anyone wishing to speak. If you wish to speak on an item on the consent agenda, we ask that you stand and state that item. That item will then be removed from the consent agenda and scheduled as a separate public hearing under Section 3 of today's agenda. All items remaining on the consent agenda will be voted on in total with a motion for approval. Jerry, will you please call the consent agenda items?
Sure. Please note that the applicant for item 1.4, which is preliminary plat 16006, has requested a 2-week deferral to the December 14th meeting, so action will be taken under deferral on that item. I will not be calling it under the consent agenda. And also note that item 1.3 changes zone number 16036 is being removed from the consent agenda for a separate public hearing as we've received some opposing comments on that application. So the first item under consent on the consent agenda is item 1.1, text amendment number 16014 to revise section 27.61.090, continuation of non-standard uses to clarify the application of automatic adjustment of setbacks for existing parking and other uses when a government agency acquires land of right-of-way. Next item under consent is item 1.2, change of zone number 05054E from AG Agricultural District to R5 PUD Residential District Plan Unit Development. to add approximately 7.37 acres, more or less, to Prairie Village North PUD on property generally located at North 89th and Fremont Streets. And the final item under consent agenda is item 1.5, which is use permit number 26A for the conversion of existing units from hotel use to apartment use with waiver from required yard setbacks and waiver from minimum parking requirements on property generally located at 200 South 68th Street Place. Are there any ex parte communications to be disclosed on these consent agenda items?
I see none. I'd entertain a motion.
Move approval of the consent agenda, core.
Thank you.
Second, Lust.
Thank you. Jerry, please call the vote.
Cornelius?
Yes.
Core?
Yes.
Harris?
Yes.
Lust?
Yes.
Sunderman?
Yes.
Washington?
Yes.
Weber?
Yes.
Shear?
Yes.
Hove?
Yes.
Motion carried, 9-0.
I'll now ask Jerry to call any requests for deferral received prior to this meeting.
Okay, we had two separate requests have been made for 2-week deferrals on agenda item 1.4, preliminary plat number 16006, which is a new preliminary plat to create an industrial park consisting of 9 lots on property generally located at South 25th Street and Saltillo Road, and a separate request for a 2-week deferral on item 2.1, which is text amendment number 16019, to amend sections 27.06.180 and 27.62.150 of the Lincoln Municipal Code to add assembly facilities as a conditional use in the H4 district and repealing sections 27.06.180 and 27.62.150 of the Lincoln Municipal Code as hitherto existing. And this would defer both of these items to the December 14th hearing.
I'd entertain a motion for deferral.
Move deferral, Lust. Second, core.
Thank you. Jerry, please call the vote.
Cornelius?
Yes.
Core?
Yes.
Harris?
Yes.
Lust?
Yes.
Sunderman?
Yes.
Washington?
Yes.
Weber?
Yes.
I will note that Commissioner Scheer has declared a conflict of interest on preliminary plat number 16006, therefore he's not voting. And Hove.
Yes.
Motion carried, 8-0.
Is there anyone here wishing to speak on preliminary plat number 16006 today rather than waiting until December 14th? I see none. Is there anyone here wishing to speak on text amendment number 16019 today rather than waiting until December 14th? Don't see anyone. We will move on. We will now proceed to public hearings. The staff will make a brief presentation. The applicant will then be requested to present his or her testimony, followed by those who wish to testify in support, followed by those who wish to testify in opposition. The staff will then be given an opportunity to respond to the testimony, and then the applicant shall have an opportunity for rebuttal. Each person testifying should state their name and address and shall have 5 minutes to speak unless additional time is requested and granted. The timer will go off after 4 minutes, then you will have 1 minute to wrap up your testimony. The Planning Commission will vote immediately at the close of the public hearing unless the Commission votes to defer action or continue the public hearing. Jerry, please call the first public hearing item.
Okay, I'll be calling it as item 3.1, change of zone number 16036 for the Wilderness Hills Commercial Planned Unit Development, replacing use permit 154 to allow up to 162 dwelling units and 375,065 square feet of commercial floor area on property generally located at the southeast corner of 27th Street and Yankee Hill Road. Staff recommendation is for conditional approval. Are there any ex parte communications to be disclosed on this application?
I see none. Rachel.
So this application is located at South 27th Street and Yankee Hill Road, southeast corner. This is Wilderness Hills Commercial Center. And the application before you today essentially would convert their existing use permit to a planned unit development to allow for dwelling units, apartment units to be constructed in the southeast corner. There are some changes to square footages within the center, but the main change in the portion that we received the comment on is regarding the apartment units, and again, those are proposed in the southeast corner, east of South 30th Street and south and north of Wilderness Hills Boulevard. Currently, the site proposed for apartments is approved for a mix of commercial, office, and hotel room units. And notably, the southernmost portion is approved only for office uses. So they'd be proposing to construct 3 apartment buildings. It should be noted that the applicant is actually requesting 166 apartment units, not 162. And as far as surrounding land uses, we have the rest of the commercial center to the west and to the north. On the east side is an existing apartment complex, and then to the south of Wilderness Hills Boulevard, are single-family homes. There would be required landscaping for these buildings on the south side, a screening of 50% from 6 to 15 feet. So that's just a standard screening that's required for multifamily buildings, and we would be waiving that requirement on all sides except the south side, the reason being that there are single-family homes south of these proposed apartments. With that, I'll see if you have any questions for me.
Questions?
I have a couple.
Tracy?
Yes.
First, can you point out, I know you mentioned it, can you point out where the existing apartments are right now? Did you say to the west?
Yeah. So this is the proposed apartment site, and the existing apartment complex is on the east side.
And so in the letter of opposition that we received, those are the apartments that they're referring to?
Right. I think that's what they're referring to as the objection to expansion of additional apartments in this area.
And then on the diagram that you had up before, the kind of the grayed out buildings, it looks like there's maybe 3 of them, well, maybe 4. Is that the proposed apartment complex, or is that from the previous plan with the hotel?
No, this is the current proposed plan.
Okay.
So there'd be 3 buildings, and then also there'd be a 4,000 square feet of commercial approved here in the northwest corner, adjacent to the roundabout.
I did have I was a little confused when I was reading in your analysis on number 3, when it talks about the lot 24 and the medical and office uses. It seems like the 2 sentences kind of contradict each other. So is it only going to be office medical, or is it opening up to all B2 uses?
Let's see, let me check. Quick. So lot 24 would be open to any B2 use.
So basically it's going, before it was restricted to just office medical, and now it's
Right.
any B2
Right.
use. Okay. And then I think really my other question is about the traffic and the daily trips, because when I was reading that, it seems like, okay, so the apartments with 162 or 166 units was 1,077 daily trips. And then if the estimated with the existing, let me look at those numbers and then I'll
Okay,
figure
where
it
are you
out.
seeing those?
I think that came out in an email from Mr. West.
Okay, okay.
So he might be able to answer that question better.
Yeah, I probably couldn't answer that one, other than if Public Works is here and they'd like
Okay.
to speak to it.
Thank you.
Any other questions? Thanks, Rachel.
Thank you.
Applicant?
Brett West, the applicant. I work for Assurity Real Estate representing Wilderness Hills LLC, who is the owner of Wilderness Hills, which includes Speedway, ourselves, and Lincoln Federal. So we are looking to work on the apartment complex with CIP here, who is a local apartment developer, lots of experience, so they definitely know the market. So we're partnering with them, which we feel is a good use. I've been working on this project just for about the last year and a half. The project's been in place for over 10 years, and really this use change comes because we have had zero activity for office space in the south market, and we still have available lots for this. Also, as we looked and continued to try to make sure that Wilderness Hills has some long-term success, the inability to get this pad activated with people there to shop at our stores, to create that walkable community, to activate that street on 30th Street, which would really have struggled to get tenants there. This felt like a really good use. And a couple of things that I'll add to this, not only are we looking at the apartments, but we are doing 4,000 square feet of at the roundabout, if you've been down there, to activate the corner, hoping to get some compatible use to continue that connection to the retail that we've invested in thus far. So those are the major changes and kind of a little bit why. And I don't believe in your packet you have kind of an image of what we are planning to do. If I could turn on the camera for 1 second, I can give you some of. Okay. So this is the roundabout right here. These would be the 3 buildings that we would be proposing in that location, and they largely stay with what was originally in the plan, which was a 2-story commercial, up to 3-story if it had a hotel. So we are trying to stay compatible with the guidelines that we put in place for materiality, and really highlighting that corner to kind of create that destination place. And we're really hoping that this, combined with the other lot that's discussed, and we're getting some traction out there on the outlots, will really activate this corner and kind of help us finish the development. To answer your question about trips, so the email that I sent regarding trips, I had Brad Marshall with Olson and his traffic study engineers give me the feedback on what was the previously approved. So the existing use permit with retail and office, that would be in that back corner. If that were developed, it would have created these 2,500-ish trips. If it would have had a hotel, it would have almost gone up to 3,000 or over 3,000. So with our proposal, it actually reduces the trip generation from the center down to around 1,000 daily trips. The breakdown of our apartments, we have 15 studios, 82 one-bedrooms, 62 bedrooms, and of the 3 bedrooms, we have 9. So we have 166 units. I apologize for not catching the typo of 162. That was my error. So that creates about 244 beds. So it is a lot more 1-bedrooms than you're seeing down in the market. So we've had questions about, well, what's the marketability? We're adjusting that with the market, but we still think South Lincoln, even with all the apartments, especially on 27th Street, there's still a strong need. So any questions for me?
Questions for Mr. West?
So we're looking at about a 1,500 daily trip decrease going from the hotel
Yes,
office mix to this apartment
that's
situation.
correct. And there was a lot of retail planned on the first floor, so I want to be clear about that. And that doesn't exist anymore. 10 years ago, Amazon didn't exist, at least what it is now. So,
Janelle?
Yes, is it primarily going to be surface parking or is there underground
no,
parking?
every building has underground parking, so 1 stall per unit will be underground, and then roughly 1 to 1.25 will be above ground. And we have some surface garages that you'd see in my packet here. So,
Other
combination.
questions? Thank you very much.
Thank you.
Is there anyone here wishing to testify in support of this item? Is there anyone here wishing to testify in opposition to this item? Please come forward.
My name is Gary Morgan. I live at 8910 South 30th Street in Wilderness Hills. We were notified of this whole proposed development 8 days ago. And we are generally concerned about just the quantity of apartments that are in this area. And this also includes, I mentioned in my email, and it was part of an Olson drawing that showed apartments east of Aventine Apartments on the other side of, I think it's 33rd Street, which that kind of alarmed me that, where's all this going to stop? Now, I live within about 200 feet of this proposed development. When I moved there, there was nothing there. I did a little bit of checking on zoning and thought, okay, I can live with that. But just to keep pouring apartments into the area, I can't support that. I have not had time to try to organize to talk to the homeowners association other than by email. And I feel that I would like to ask you to just postpone action on this until I've had time to gain a little bit of support to present a better argument than to say I don't know anything. But that's basically where I'm coming from today.
I have a question. Oh,
Go ahead,
Can you clarify for me what the issue is with more apartments? Why you're in opposition to more apartments in the area?
No, I can't. I can't clarify. That's why I need more time. I just generally am opposed to seeing a bunch of apartments in that close proximity to a residential area. There appears to be no real buffer that is going to help a bunch of trees that will be very small for a long period of time. But so that's really where I'm coming from.
Other questions? Thank you very much. Is there anyone else here wishing to testify in opposition to this item? Do we have questions for staff?
I have one.
Okay. Rachel?
Rachel, this isn't final action with us, is it?
No, it's final action at city council.
So do you know when it would be in front of the council? So how much time the neighborhood would have if they wanted to present some concerns?
It would be December 19th. Is that right, Jerry?
That's correct.
Thank you.
Other questions?
Oh. Let's see.
I
That
don't
is
think
correct,
that's-
yes. It would be an evening meeting at 5:30.
Do you have questions for the applicant, or do you have anything you want to say? Come on up.
Yeah, just one response to that. I did meet with the homeowners association leadership. So I did go to a meeting. I don't know if I don't run their part, but I believe they did advertise that I was going to be there. And I'm planning to be at the December 6th meeting, which is an all meeting. So I'm happy to discuss with them further. And I provided packets for them to paste. I think they post stuff on Facebook. So I don't know, but I'm happy to be there on the 6th to discuss what we're proposing and get into some of the details. And we've discussed a couple of ways that maybe we could help with buffering and the medians along there between the two developments and partner up on that with the homeowners association. So I will be at their 6th meeting if I can and try to address some of those, but we'd like to move forward knowing that ultimately Common Council will review this as well.
What is the buffer that you have set up at this point?
Do you remember on the south side? Do you recall what the buffer is? I can't. You're talking about the physical buffer?
Yeah.
We
just
haven't
to-
we haven't gone beyond what was originally approved.
Okay.
20, it was previously and still is showing as a 20-foot setback on the south side.
Okay.
There is a median in between those as well. And that really, when the roads were developed, I understand is actually the homeowner's responsibility, homeowners association responsibility. But I've told them that we would look at a proposal to help get some trees planted in there. So we'll work something out.
I'd entertain a motion.
Move approval. Lust.
Second, Cornelius.
Discussion?
I appreciate the testimony from the opposition. However, I think there's sufficient time between now and the city council meeting to organize testimony for that. Otherwise, I think this application represents a general positive for the area, and that's why I am in favor of it.
Anyone else? I just echo what Michael said. I think, I appreciate what the opposition said. It does have some time, but I think this helps this area and brings it to a good use. Jerry, please call the vote.
Okay, this is for conditional approval of change to zone 16036. Cornelius?
Yes.
Core?
Yes.
Harris?
Yes.
Lust?
Yes.
Sunderman?
Yes.
Washington?
Yes.
Weber?
Yes.
Shear?
Yes.
Hove?
Yes.
Motion carried, 9-0. Next item is item under public hearing administrative action, comprehensive plan conformance number 16011 to review as to conformance with the 2040 Lincoln Lancaster County Comprehensive Plan, a proposed amendment to the Lincoln Center redevelopment plan to create the 1222 P Street mixed-use redevelopment project. And I want to just make that notation, it should be project rather than plan. Generally located at 1222 P Street and within the Lincoln Center redevelopment plan, bounded by Salt Creek, Interstate 180, and R Street on the north, 17th Street on the east, G Street on the south, and Salt Creek, and 2nd Street and Sun Valley Boulevard on the west. Staff recommendation is for conformance with the comprehensive plan. Are there any ex parte communications to be disclosed on this application?
I see none. Dallas?
I'm Dallas McGee with the City Urban Development Department. As Jerry indicated, this is an amendment to the Lincoln Center redevelopment plan that will allow for a project area to be created that allows for redevelopment of this parcel and the use of tax increment financing to assist in that development. The building is known as 1222 P Street, probably better known as the former home of the Swanson Russell Advertising Agency. They have moved next door and expanded and made this building available for redevelopment. It's been acquired by Brick and Mortar Development, and they have plans to develop a mixed-use facility here, actually adding 3 floors to the building, and it would have commercial on first floor as well as 4 floors of residential above there. There are representatives here from the developer, and I'd be happy to answer any questions or let them expand further.
Question for Dallas? Guess not. Thank you.
Thank you.
Good afternoon, Mr. Chair, members of the commission. My name is Tom Houston. My address is 233 South 13th Street, Suite 1900 here in Lincoln on behalf of the developer, Brick and Mortar, owner of this building at 1222 P Street. With me today is Matt Stricker, who's the principal and owner of Brick and Mortar. This project provides a unique opportunity for the redevelopment of this property. The city of Lincoln has invested a huge time and effort and resources into the redevelopment of P Street as a retail corridor, and this project will fit very nicely within that framework. A little bit about the project initially. On the overhead, you will see the project area with this property located on the north side of P Street. The project area would include the alley. This project would entail the retention of the front approximately 20 feet of the structure and the demolition of the balance of the building back to the alley. There will be a reconstruction then of a new facility retaining the front historic facade that ultimately will result in a 5-story building with 4 stories of residential areas to accommodate 29 dwelling units consisting primarily of studio and 1-bedroom units. The first floor retail of approximately 4,000 square feet would then be available to activate this space as a part of the P Street retail corridor. The issue really in front of the commission today is whether or not this amendment to the redevelopment plan generally conforms with the general plan of development. In the city of Lincoln, that general plan of development then is embodied in both our comprehensive plan and the downtown master plan. I just wanted to highlight a couple points for you. The comprehensive plan that was adopted for L Plan 2040 evidences a goal for a commitment to a strong downtown, a goal of increasing choices for residential lifestyles, a goal for the encouragement of mixed-use development, and a new focus on development of new dwelling units with a goal of adding 3,000 dwelling units in downtown Lincoln. That was 5 years ago. We're well on the way towards the achievement of that objective in the downtown residential development. The downtown master plan for the city of Lincoln also states goals that this plan helps to accommodate. One is to encourage mixed-use development in the downtown area for both housing and retail. The downtown master plan states a goal of enhancing the retail corridor to sustain pedestrian activity and encourages a vertical mix of housing over retail. This project itself will entail approximately a $4 million investment by the developer and approximately utilize approximately $470,000 of tax increment financing for primarily the demolition and site preparation for this project. The schedule would be, once approved by the City Council, that we hope to start construction as soon as weather would permit in 2017, with the buildings and units being available for rent sometime in 2018. So with that, I'd ask for your support for this project and be available for any questions that you may have.
Question for Mr. Houston?
I know this is a little bit outside of our purview, but, so I'm a little confused when I was reading the plans and the comments from the Historic Preservation.
Urban design.
Yeah, that one.
Yes.
Thank you.
Urban Design Committee, yes.
So you're keeping the first 20 feet
Mhm.
of the building, and then you're going up, so this picture on the
Yeah.
right here is more illustrative of
Yeah,
what it's going to look
this
like.
is the existing historic facade, and that facade's being maintained as a part of this development. This first floor area would be retained as retail development to activate that P Street corridor, residential on the upper 4 stories. There was several comments at Urban Design Committee. This master plan, or this elevation drawing that you see, is trying to address some of those comments of urban design. This project will go back to urban design first part of December for their review and additional input.
How tall is the building to the right, or to the east side of that one?
On this side, that's the Cadillac Flats, and it's my recollection, that's a 3-story building.
So this would be a little bit taller than that.
Correct.
And now, it looks to me like perhaps there's a garden level, and then, so the first floor is actually kind of raised up on this existing?
One of the challenges of this building was the split level entry, and this project will enable us to remove that problem. But the building, as originally designed back in the 1880s, was a residential building. It was converted to an office use in the 1920s, as I recall, and we're trying to restore it back to the residential area and remove some of those barriers.
So will it become more of a first, entry level?
At the grade level, yes. Finished
Okay.
floor level, yeah.
Thank you.
Other questions? Thank you.
Thank you.
Is there anyone here wishing to testify in support of this item? Is there anyone here wishing to testify in opposition to this item? Do we have questions for staff? Or anything else you'd like to add? I'd entertain a motion.
Move a finding of conformance.
Second Lust.
Harrison Lust. Discussion?
I don't think there's anything about this application that doesn't conform. It's a great example of mixed use, infill. It's great to see investment in P Street. That was the point of the entire exercise of pouring public and private investment into P Street, and I think I appreciate the effort to maintain the facade, and I look forward to seeing what's going to happen. I think it'll be a great thing.
I just want to add that I appreciate the fact that you're going to continue to work with the Urban Design Committee for the next few weeks at least and resolve some of those issues. It's really great.
I agree with Maya that this does fit in conformance with the plan. My concerns are more just aesthetics and making sure that we retain that historical component, and it did look a little out of place, that upper story. So if we could find some materials that would maybe blend that in a little better, but I trust the Urban Design Committee will take care of that.
Yeah, anyone else? I'm going to support this item. I think it is a good use and good change for that building and an upgrade. Jerry, please call the vote.
Cornelius?
Yes.
Core?
Yes.
Harris?
Yes.
Lust?
Yes.
Sunderman?
Yes.
Washington?
Yes.
Weber?
Yes.
Shear?
Yes.
Hove?
Yes.
Motion carried, 9-0. Okay, the next item is item 4.2, text amendment number 16013, an ordinance amending chapter 27.63 of the Lincoln Municipal Code relating to special permits by amending section 27.63.685 to delete the access door location requirement and add exterior door opening requirements for a special permit for alcoholic beverages to be sold for consumption off premises in zoning districts B1, B3, H1, H2, H3, H4, I1, and I3, and repealing section 27.63.685 as hitherto existing. Staff recommendation is for denial.
Brian?
Good afternoon, Brian
sorry.
Will. Sorry?
Are there any ex parte
Oh, sorry.
communications to be disclosed on this application?
Yes, I attended the Mayor's Neighborhood Roundtable on the 14th where the applicant presented.
Anyone else? Sorry about that. Brian?
Good afternoon, Brian Will, Planning Department. As Jerry noted, this is a proposed text amendment to Special Permit 2763-685. Maybe just a little bit of brief history here to maybe hopefully avoid some confusion as we move forward on this one. Recall that in order to sell alcohol within the city of Lincoln, it requires two things: a liquor license from the state of Nebraska and a special permit if you're located in one of those districts where the sale of alcohol is allowed. Now, we have two special permits. One is for technically the sale of alcohol for consumption on the premises, and this one for consumption off the premises, off sale, for convenience. So this amendment today just modifies the special permit for off sale, does not affect the other special permit for on sale. And so the amendment before you today has two parts, and let me kind of briefly talk about them and the way that staff viewed them. The first one is probably, well, I think we suggested it's maybe one of the more significant components here, but it seeks to modify the separation, the required separation in the special permit that's required of the licensed premises from first floor residential use, daycare facility, park, place of religious assembly, or state mental health institution. That is a component of both special permits. I would note that that required separation has been a part of these special permits since they were originally adopted in 1994. I'd also add that these special permits, both of them have been modified many times, as you're looking through the history here in the staff report, and they're both like that. They've both been modified several times in their lifetime. But that is one thing that has pretty much remained, or has remained constant in both of them, is that required separation. So as we started looking at this text amendment, it seemed to us that the overriding question that we're going to get asked, have been asked, well, what is the impact of this amendment if it were approved? There's probably several different ways to quantify it. This is the way that we chose to quantify it. This exhibit is an overall map of the city of Lincoln. I'd ask you to please disregard the green and the pink. Those don't have any relevance in this case. What this is trying to illustrate is those zoning districts that would be affected by this amendment, that is the B1, the B3, all of the H districts, I1 and I3. So those districts are highlighted across this map, and it's just to illustrate that this is a text amendment to the zoning ordinance, means it affects the entire city and the 3-mile extraterritorial jurisdiction. So all of those areas subject to Title 27 would be affected. And so what's highlighted here in the purple and the sort of red and the blue are those districts affected. And so it's obvious that, yes, along Cornhusker Highway, the downtown core, or beyond the downtown core, south 13th, 14th. Corner Highway, of course, we know those are typically more heavy commercial areas. What I'd note, though, is those areas that are also affected throughout the core of the city, those smaller blue areas, and most of them in the core are typically B1, B3. And as we get outside towards the edge, we do have the B2 typical suburban commercial centers. But inside the city, inside the core, typically it's B1, B3. So what was the effect of this? We overlaid two buffers, the 100-foot buffer currently in effect, and to assess the effect of that, also overlaid the 50-foot buffer. And so what we found using that map is that currently there are 1,524 buildings located within that 100-foot residential buffer, okay? And when we overlay it with the 50-foot buffer, we find that there are 651 of those now would become eligible that previously weren't eligible, didn't meet the separation, okay? Now, I'm not suggesting that this analysis here says, oh my gosh, now, if this is approved, that there are 650 buildings that would now be eligible. What we're saying is the potential here by this amendment is that there are an additional 651 buildings that become potentially eligible because the separation is reduced from 100 feet to 50 feet. And so what does that look like? Here's just, this is sort of these are in your packet. These are some exhibits to graphically, I don't have my glasses on. There we go. Okay, to graphically illustrate what I'm talking about. And so the black line that we see here is the residential, or the 100-foot buffer from a residence, a church, and we see how it encroaches into, this is the small commercial center that's centered at A Street, South 33rd, okay? And so we overlay that 100-foot buffer. That is the black line. And so any building within it currently is not eligible, right? So we then overlay the 50-foot buffer, and still a majority of those buildings, those that are all purple, are still not eligible. But this just illustrates that in this case there are 4 buildings that would then meet that 100-foot separation. Now understand there's 2 parts to this. We'll talk about the second part here in a minute. I'm not suggesting it meets all the requirements, but I'm suggesting on the surface, an area like this is impacted. And to take that, I suppose, a step further, sorry, we'll get it here. Okay, this is South Street from approximately 9th Street to 17th Street. And again, the same thought process, the 100-foot buffer overlaid with the 50-foot buffer. And then again, those buildings that are purple, crosshatched in yellow, previously would not have been eligible, but now would be. So it's this same sort of theme throughout the city. Just to show another one, this is North 27th Street from approximately S Street to Potter, and again, the commercial zoning along 27th Street corridor. Again, multiple buildings in that area that also previously weren't but would be eligible if the separation distance is reduced. So the second part of this then brings over some of the criteria, the conditions from the B2 and the B5 zoning districts. So I want to note here that we're talking about all the commercial zoning districts affected by this. There are 3 that we haven't talked about yet. It's B2, B3, and, B2, B4, and B5. B4, of course, is our downtown core. Sale of alcohol is a permitted use there. It's allowed. No special permits required. No conditional use. The two districts that have been separated out actually from the beginning were the B2 and the B5. And really the reasons for that are twofold. And I noted in the report, I think primarily, number one, those were the new suburban commercial shopping center zoning districts adopted with the zoning update in '79. And so those are both what we call use permit districts. There's already a site plan review involved in the approval of those required by the city. So the city already has a review, is already involved in a review of that development up front. And so I think the special permit, requiring special permit in addition to that, was deemed to be redundant. Secondly, as you look at the development pattern in these newer suburban shopping centers versus the older parts of town, it's a totally different development pattern, and it's a result of the regulations between the two. And so what does that look like? How does that manifest itself? Well, in the case of this area here, this is, we haven't talked about this, and this is Bethany. So that corridor, Cotner Boulevard, here's Holdridge, 66th Street, the old B1 zoning. You'll notice that in places it does follow street rights of way, but in other places you find that it cuts through the middle of a block, here and here, throughout here, over here. I mean, it's the way that area developed. The zoning pattern reflects that. Another example of that is College View, same sort of thing. We've got sort of a mixed bag here along 48th Street, but then the zoning district boundary weaves throughout the neighborhood. It does follow the street in some areas, but not consistently. Contrast that with the newer centers that we have in the suburbs, sort of the newer areas out at the edge of the city. This one here is Pioneers Boulevard along the north. This is South 70th Street. This is southeast of the intersection. The B2 is in green, so the shopping center is here, surrounded by apartments and then single-family residential to the south. But you see the development pattern is different. We don't have a zoning district, zoning boundary line going through the middle of a block. We have a 50-foot buffer here along the edge. It's landscaped, it's screened. These buildings, they're either oriented toward the major arterial streets or inward to one another, parking surrounding those buildings, separating one another. Maybe a little bit older example, but of the B5 model, which is our regional shopping center. This is Edgewood, South 56th, Highway 2. Edgewood has a 100-foot setback all along the north and the east edge. This is the office complex to the south. It as well has a buffer. But the shopping center itself is screened and buffered, and again, parking generally internally, buildings generally oriented inward. There's a lack of street connections to the adjacent neighborhood. So this was the rationale, I would argue, primarily for separating out the B2 and B5 originally as permitted uses to get alcohol. Subsequently amended, it's now a conditional use. The development pattern is just entirely different than those older B1, excuse me, and B3 districts throughout the city. So modifying the special permit that is used in B1 and B3 to include that condition that is used for the B2 and B5, in our view anyway, is inappropriate. So with that, the planning department is recommending denial. We find that this amendment isn't supportive of any tenet in the comprehensive plan. It doesn't further any goal of the plan. If approved, it would only serve to allow alcohol at locations where it's currently not allowed. And I think some would probably argue that were originally intended to be prevented by the ordinance, special permits as they exist. So with that, I'd be happy to answer any questions you might have.
Janelle?
Has there been, initially when the buffer zones were adopted, was there any studies or anything looked at about, why the buffer zone was 50 rather than 100, and why, and how does that protect the neighborhoods against the evil we're trying to protect them from of, having the alcohol sales and closer? I mean, how did we land on 100? What was the rationale for it? And was that based on any studies that you're aware of?
Well, at this point, my relating that history to you is a combination of anecdotal and what I have read going back through those files of the adoption of the original ordinance. But I think it was twofold. I think there was this element of trying to maintain some reasonable separation between these uses, sale of alcohol, and the adjacent neighborhood. Now, I can tell you that what I've read is that several different separation amounts were discussed and used. 50 feet, 100 feet, 150. From what I can tell, those others were dismissed. 150, that sort of separation would eliminate virtually all the older commercial districts. 50 feet just didn't seem to get there and just didn't seem to eliminate enough possibilities. And so I think it was sort of, from what I can tell, a compromise landing on 100. And so I think it was separation just not only to, provide some distance between the two, but it also has the effect of limiting proliferation and concentration in some areas. I know areas at the time that were of concern are, were the older, excuse me, districts like specifically North 27th, North 48th. Going something less than that would not have had the desired effect.
And one kind of follow-up question for that. I think one of the amendments to the proposed language by the applicant was to not only have the 50-foot buffer, but if there was a street right-of-way between the proposed site for alcohol sales and the residential district, that would be sufficient. Do you have a position on that, on the street right-of-way being a sufficient buffer?
I do.
Okay.
What I was going to do, however, was I think that individuals probably here, let them present that to you. We've only gotten that in the last couple of days. I'll be honest with you, some sort of detailed review of that, it just isn't possible. But I do have thoughts, and I think a recommendation as well, but wanted to let the applicant talk.
How wide usually is a street right-of-way?
Well, a typical public street, local street is 60 feet. That's the majority of them, but you get in the older parts of town and you get some that are less. There's some unusual circumstances out there.
Maya?
So if I understand the staff report correctly, until 2004, planning had some discretion to waive or lessen the separation if there were mitigating circumstances.
Correct.
Do you know if what planning's position was on that change in 2004? Planning thought it was working well the way it was, or it was a problem? And
We were supportive of the change.
you were, okay.
Well, as I suggested in the staff report. The problem with the ability to adjust and waive that 100-foot separation on a case-by-case basis, like as I noted, I think applicants were complaining that they were being treated differently. It'd be hard to come up with a basis for denial. If somebody just got 50 feet, I only want 40, how can you deny me? So being consistent and being equitable in all cases was difficult. Plus, staff was in a position of having to determine what was adequate mitigation in the case of something less than 100 feet. So I think the city council and the planning commission weren't comfortable with that system as it was working because it had an element of subjectivity that was probably more than everybody was comfortable with.
Other questions? Thanks, Brian.
Okay.
Applicant?
Mr. Chairman, members of the Planning Commission, I'm Mark Hunziker, appearing on behalf of Walgreens. I'm always amused when I hear people talking about the history of this ordinance. I wrote it. So if you want to know about the history later, which I think is irrelevant to this application, I'll be glad to give you a little more firsthand knowledge of it. The issue here is the difference between the B2 and B5 commercial districts and all other districts relative to the objective criteria of distance from those protected uses, churches and residential and so forth, for licensed premises versus the public entrances. Why is it okay to have a liquor licensed premise 50 feet or less? There is no minimum in the B2 or B5 from the protected uses in those districts, but nowhere else. If the distance to the public entrance is the standard in B2 and B5, why not in B1, B3, or H1? If that distance is important, if it can be reasonably said to create a meaningful protective buffer between a premises which sells alcoholic beverages for consumption off the premises, then it should apply to all zoning districts regardless. This proposal does not change provisions for bars. Arguably, those establishments have a greater impact on abutting residential properties than off-sale. Yet our ordinance today makes a distinction based on the zoning district. And Brian, do you have that South Street corridor map? I want to just take one look at that. This 27, that should be it. This is it. It's okay. No, that's fine. Okay. Here's an example that's fairly recent. Actually is in a B3 zoning district. It's Piedmont Shopping Center. There's a restaurant that serves alcohol right there, and it's well within the 100-foot buffer, but it's not required to have 100 feet. It's in the B3 district, but because there was 3 acres available, we could apply for a PUD, and we got exempted from that 100 feet. This is an example in a newer shopping center, Zone B2. This access would be 18th Street on Pine Lake Road. This building houses a restaurant called Isara. Nice restaurant. They sell alcohol. They also have an outdoor patio where they serve food and alcohol. And it's about 50 feet from all these residential dwellings to the south. A little ways down the road on Pine Lake is another large commercial building, about 50 feet plus or minus from residential. This townhouse right here is maybe a little less than 50 feet from the building. That entire building under the B2 district could have off-sale or on-sale alcohol. So there's really nothing magic about 50 feet versus 100 feet. It's all about the distance, at least in those districts, around the building to the front door and where the activity is going to be. Now I want to show you a picture of 14th and Superior. This is the Walgreens at 14th and Superior as it existed when it was zoned B1 and could not sell alcohol. This is a picture of Walgreens, now zone B2, within 100 feet of the park on both sides, and it sells alcohol. The reason we're asking for this change is this store at 48th and O. It's about 65 feet from the residential property line to the south. But the residential property line to the south is marked by about a 10-foot retaining wall. It sits 10 feet above this parking lot. There's no ability to waive that. We don't have 5 acres of ground to zone it B2. We don't even have 3 acres of ground to zone it B1 PUD. But the results are absurd. If distance is the criteria and distance to the main entrance is the criteria in B1 and B5, or B2 and B5, then why should it not be in those other districts? The use of the alley, the maps that were shown don't tell you anything. The fact that an alley is the boundary of the zoning district doesn't tell you anything about where the activity is relative to the abutting residential. Measuring to the front door of the premises where the activity is a much more relevant and I think protective measure. And the B2 and B5, were set out because they weren't deemed to be needed. This wasn't needed, but I'll tell you, the real reason that this ordinance was passed in the first place was anti-competitive. It was an effort by the existing Retail Packaged Beverage Association, now defunct, to restrict the number of C-stores that might be able to get a license after the old separate and distinct ordinance was declared unconstitutional. If you want any more history on that, I'll tell you, but I think I've run out of time.
Questions from Mr. Hunsaker?
Mark, why not just propose a text amendment to measure to the front door instead of reducing the buffer from 100 to 50?
Actually, what I tried to do was just that, but it was necessary to change that 100 foot to 50 in order for there to be a minimum. If all I had done was taken the B2 and B5 provisions and substituted them for the existing provisions in all those other districts, there would be no minimum. There is no minimum in the B2 and the B5. There is a measurement of distance from parking spaces in the side yard in the B2 and B5, but in that instance, the distance of the side yard is presumed to be 50 feet. And so I took the 50 feet and said, okay, that's a minimum that we ought to have, and put that in lieu of having no minimum.
So, for example, the Walgreens that you're representing, if we measured the 100 feet to the front door rather than to the back of the premises, would you be in compliance?
Yes, absolutely, by a lot.
So,
Both ways, distance from the building from the residential and...
We would have more than 50 feet to the property line, and we would
would it
have
be-
more than 100 feet to the front door.
Other questions? Thank you.
Thank you.
Is there anyone here wishing to testify in support of this item? Please come forward.
Hello, my name is Brandy Payne, and I'm the chair of the board for Open Harvest Co-op Grocery at 1618 South Street. And I'm here representing the board, management, staff, and many member owners and patrons of the store, including over 300 that have signed a letter in support of what I'm presenting here just in the last week. This has been a quick effort on our part, so it's ongoing. I'm here to request that we amend, or that you amend, Mr. Hunsaker's proposed text amendment with his permission to include language at the end of Section 1, subsection C, to state, however, if there's a public street right-of-way between the licensed premises and premises described in 1 or 2, the distance shall be the width of the public street right-of-way, as you were mentioning. So I believe you received this request in advance. Hopefully you've had a chance to at least glance it over. Now, we do understand and appreciate the concerns about amending the code dealing with the sale of alcoholic beverages for consumption off the premises. And we would rather approach the city for a waiver, as you discussed, but that's no longer an option for us. And so it's necessary then to amend the broader language that does have a widespread effect on the city. We're also aware that the City of Lincoln, through the comprehensive plan, has made it a priority to support the retention of existing businesses and sustain the functionality of the core of the city. And that's where we're located, right there on South Street. To that end, amending this code to a degree that would allow locally owned small businesses, such as Open Harvest, to continue as a part of that core of the city is crucial. We've been around for over 40 years at the current location since the early 90s. However, competition growth over the last 5 years has hit us hard, and it's no secret we're struggling. One of the things we've heard over and over again is that we need to be a one-stop shopping experience, and not having the ability to sell beer and wine to complete the purchasing experience is hurting us. And so we're losing business, and it's getting harder to draw new customers to our current location. We're located in a great neighborhood. We provide a walkable grocery option for those in the surrounding area. We also provide food resources for surrounding businesses, and especially with the loss of a grocery store within the last couple of years across the street, we're the only grocery option along that South Street corridor for quite a ways. So if we were allowed the option to be a one-stop shopping experience, it would allow people in our neighborhood to work, live, and shop within biking and walking distance, thus reducing, as the comprehensive plan states, the energy demands and harmful emissions of vehicle trips. More importantly, the comprehensive plan puts an emphasis on prioritizing local foods, going so far as to state that within the city, community gardens, beekeeping, chicken coops, farmers markets, and local cooperative markets are all important links in the local food chain. We're the only cooperative grocery not only in Lincoln, but in the state of Nebraska. Our goal is to carry not only organic and non-GMO beer and wine, but also those from local producers. As I'm sure you've noticed, there are now a number of local beer and wine producers, and we would love to support them by offering their products in the store. Last fiscal year, over 30% of our sales came from local goods. We're working hard to support our local farmers and feel strongly about being a resource to connect consumers with local food. We've even heard from one of our local suppliers that she only sells her goods through Open Harvest because we have such a strong commitment to local producers. As the comprehensive plan notes, the city is committed to encouraging increased points of sale of local foods, and we're excited to see this as a priority for the city, as we obviously believe strongly in supporting our local farmers. And it's for that reason that we don't want to see a long-standing community-owned local business that believes in and demonstrates so many of the priorities the city has listed to be jeopardized because we can't be competitive. And unfortunately, the 50-foot setback does not fix our problem. If it did, we would be all in with that. But we do have a public street behind the store. We also would meet the 100 feet to the front door, and we've met that all along, just not to the perimeter of the building, so.
Questions from Ms. Payne? Maya?
So, if I understood you correctly, you said you'd rather have the option to apply for a waiver for
Sure.
your particular situation. So, to play the devil's advocate, why not put forward an application that proposes bringing back planning's discretion versus supporting this particular
Sure.
application?
We've considered a lot of different options. When Mr. Hunsaker's amendment came up, it seemed like a good time to jump into the process and kind of see if this was a way we could get to that, because I know that there was a lot of support for taking away that option to have a waiver. And so we thought this might be, frankly, an easier sell than trying to go back and open up that Pandora's box, depending on how people view it, so.
Other questions?
Can you tell me how long ago was it that you guys expanded into the?
That was 2009 is when we expanded.
I have a question maybe for staff.
Sure. And the general manager is here, should you need to.
I mean, planning staff.
Let's wait until, we'll come back, yeah. Any other questions from Ms. Payne? Thank you very much.
Thank you.
Is there anyone else here wishing to testify in support of this item?
Hi, my name is Marcus Powers. I'm with Zipline Brewing Company here in Lincoln. I'm testifying somewhat in a neutral capacity. We don't have any existing licenses that are impacted by this change. But I did want to kind of give you a couple points that we've encountered this law throughout our business. One is as the legislature recently changed the ability for local breweries to have more than one location. So we're able to have up to 5 locations across the state. We can put all 5 in Lincoln. We can put 1 in Lincoln and elsewhere. You might have noticed that recently we located a second location in Lincoln. We were shut down in a lot of small commercial districts where we wanted to put a location that was close and connected to the community. I know Mr. Will put up a map of a lot of commercial districts. A lot of the large commercial districts aren't exactly what businesses like us are seeking to be in. We want to help revive some of these small commercial areas. We want to be within walking distance of the community so they don't have to get in their car and drive really far to a commercial district to have a beer or to pick something up to come home with. So I think that this is kind of it's a new urbanist movement to be able to revive districts like Piedmont and many other districts in Lincoln. And so I think this law has created kind of an arbitrary lines that are challenging to being able to pick, one business or another within these districts. And that you'll find a lot of businesses are grandfathered into these areas that already provide beer, wine, liquor. I think the Open Harvest location is a good example where Brewski's sells beer next door. I think it's a CVS that's half a block away. It's probably a closer walk for the residents behind the building. As they go around the building to Open Harvest, they have to walk by the CVS where they can pick up beer and wine to go. And then they come around to the front of the building and can't be served there. So I think that no matter what the line is, this should be revisited on those bases for just a reasonable, rational, non-arbitrary fix to this issue. And then, of course, as a local manufacturer, we sell beer. So we have an interest in having it in more businesses. A high-end grocery chain like Open Harvest is a place where we find that, especially local in Lincoln, will sell on average about 3 times the velocity of beer sold at a store versus Omaha. So even a small convenience store in Lincoln, at one point we reviewed, I think it was like our 100th best selling location in Lincoln, sold more than our 5th best location in Iowa. And so any additional business we can garner in the city of Lincoln is good for our business and good for the community. So with that, if anybody has any questions, that's all I have.
Question for Mr. Powers? Thank you.
Thank you.
Is there anyone else here wishing to testify in support of this item? Is there anyone here wishing to testify in opposition to this item? If you plan on testifying, you might want to move up forward so you can be ready to testify.
My name is Russell Irwin. I'm here representing the Clinton Neighborhood Organization, which voted at its last meeting to support not changing the standards of 100 feet. You have questions?
Any questions for Mr. Irwin?
Mr. Irwin, can I get your address, please?
Address?
Yes, please.
3274 Merrill Street, 68503.
Thank you.
You're welcome.
I guess not. Thank you very much.
Thank you.
Others wishing to testify in opposition?
Good afternoon. My name is John Jorgensen. My home address is 6130 Francis Street. I'm here today speaking to you on behalf of UPCO, the University Place Community Organization, where I am currently serving as Vice President. We are here today to express our desire and urge you to oppose the change of zoning that would allow the alcohol sales closer to homes, daycares, churches, parks, and etc. In our view, it is unnecessary, it adds nothing to meaningful growth of our beloved neighborhoods, and it has, maybe albeit anecdotal, potentiality for increasing undesirable activity taking place closer to our residential areas. Of particular note, UPCO, our organization, its membership as well as its board, is comprised not only of residents, but also of local business owners and I'm here today in opposition of this measure. In any event, it is a recommendation of the University Place Community Organization that the proposed zoning change be denied. Thank you.
Questions for Mr. Jorgensen? Thank you very much.
Thank you.
Pat Anderson Cifuentes, and I'm speaking on behalf of NeighborWorks Lincoln, Lincoln Policy Network, and also myself.
Could you give your address, please?
My address is 1500 South 11th Street. And I have some charts here. There was a question about I am not in support of any changes. There's a long history of why we need 100-foot. And in the older neighborhoods, we have no protections. And this is one very, very small protection we have. And, you know, there's arguments, well, there's already a lot of alcohol sales in older neighborhoods. I know because there's a lot of arterials that run through older neighborhoods. If you just consider to the south and east here, you've got 9th, 10th, 13th, 17th, 16th, 17th, 20th, or not 20th so much, 27th, South Street, A Street. It's a lot of arterials, a lot of gas stations, a lot of off-sale. You also have walkable neighborhoods, which we really like about the old neighborhoods, but in being walkable, what you get is sometimes a lot of disorder, which is what I'm going to show you here. I want to make sure you can read the map. This is North 27th Street. So this is O Street. The white dots on here, can you hear me okay?
Yep.
The white dots are potential. If this ordinance were to change, those are potential off-sale or liquor licenses. The dots on there are quality of life calls for service that Lincoln Police Department has. As you see, the red dots are, and this is over the year in 2015. So the red dots are 59 to 99 calls. Just south of downtown, so this would be Everett near South area. Now, granted, the density in that area is also it's extremely higher than any other area in town, so that does affect some of the coloration and some of the calls for service. But nevertheless, this next diagram that's turned a little bit. So actually to the north is east. Can you see that okay?
Yep.
Okay, so this is downtown. This is smack dab downtown, where the red dots is. Now this is a cross-reference between where there are liquor licenses and the calls for service for what we call quality of life offenses, which would be assaults, burglaries, child abuse. It's a whole list of things, and I'll give you a copy of that. But as you note, when they're cross-referenced, the gray areas are where, and this is, each cylinder represents about a 4-block area. So the gray areas are where there are no liquor licenses or off-sale. But as you see the cylinders get taller and taller, that's where you get the crossover of the number of liquor licenses and off-sale.
So the height represents, sorry, Pat, the height represents the number of quality of life calls for service, and the color represents the number of off-sale liquor licenses. Is that correct? Mm-hmm. Okay, thank you.
This impacts a neighborhood. So I would ask you, when you vote today, to not think about one Walgreens on one street corner and how it's going to affect Lincoln, but think about the 651 other potential locations that are located. Again, I'm going to, and Brian had a much better map, I think. are located where there's already a lot of alcohol sales, where there's very little, if no protections. We don't have any, there's nothing in 100-year-old neighborhoods. We don't have homeowners associations that have certain rules that it's, they didn't think they needed them, I guess, 150 years ago. So I'm just asking that you look long-term when you consider your vote today and think about the broad effect that this has and the effect that it has on the quality of life for people living in, especially the 100-year-old neighborhoods, because those are the places that are most going to be affected.
Thank you.
Thank you.
Any questions?
Yeah.
Janelle?
Your map is not saying that the calls for service were actually to the places where the liquor was sold, just in the
No, it's
same
in the area.
general area.
Yeah,
Okay.
they go in, buy it, and usually within a couple blocks. That's where it starts showing up.
Any other questions? Thank you. Anyone else in opposition?
Russell Miller, 341 South 52nd Street, Lincoln. I sent you an email, well, you received it on Monday, about my position in opposition to this ordinance. The trouble with dealing with memories, and that's what I'm going to talk about, is that it's hard to remember exactly what happened 20 years ago. But I remember very distinctly in the late 90s where we had a situation, and when some of these ordinances, these setbacks were first put in place. There's a location at 48th and Randolph, southeast corner. There's a gas station. Well, at that time, there was a gas station on both of the east corners, southeast and southwest, the northwest. And both of those stations started to put in off sale. The location on the south east corner was having troubles with people buying off sale cold beer and then consuming it out in the parking lot. And right adjacent to that parking lot was residential homes. And that was the problem. And that was one of the things that got people upset enough and started agitating to get this setbacks put in. And I'm not sure why they got to 100 foot, but that's what we did. It was a long, bitter battle. It was very contentious with a lot of bad feelings. Now, today, that location at 48th and Randolph, he bought in 2001, the owner of that gas station bought another lot to the south, which allowed him to put in the building that you see today, which they built in 2002 or 3. So my point is that there is we have a long, we're talking about long time periods, and just what might be nice today will not necessarily be nice 10 years from now or later. The alcohol is not there's nothing wrong with drinking with alcohol, but it's no great honor either. It just caused a lot of troubles. Changing the subject just a little bit, in my email I recommended or asked that you have all off-sale be warm beer. And sometimes people think that's kind of humorous, but earlier, several years ago, I drove semi-truck. And as you may know, as you do know, semis set high off the ground. But most people aren't aware of this, but the semi driver he can look down into the cars that pull alongside him. And you can see what's in there. And it always amazed me. This not every car, of course, but there were always cars that, and this would be at between 4 and 6 o'clock, that would have open cans of beer they were drinking. And the question that went through my mind was, well, where are they getting this stuff? Well, they must be getting it at an off sale, and it must be cold, and now we're consuming it on the way home. Okay, that's not safe. I got another 30 seconds?
1 minute.
1 minute.
Okay. My solution to it would be then to reduce DWIs is simply make them drink warm beer. And let it go that way. That's what I have. Thank you.
Thank you, Mr. Miller. Any questions? Thank you. Anyone else in opposition to this item?
My name is Richard Bagby. I'm here as president of the Witherby Neighborhood Association, the immediate neighborhood association right around 48th and O location. And my personal address is 389 South 47th Street, so I live just 3 blocks to the south of the location of the focus of question for this amendment. The Witherby Neighborhood Association represents 33rd to 56th Street, the first 6 blocks south of O, about 4,000 residents of the city of Lincoln. And NeighborWorks was here to present the position of the Lincoln Policy Network, which we do support. We are assignee to the Lincoln Plan for Action of the Lincoln Policy Network, and we heartily support that from a citywide perspective, and I'll refer you to NeighborWorks for the citywide perspective. I'm here to give the perspective of the immediate neighborhood around 48th and O, and that is we are well served by the current policy, and we encourage no change to the current policy. This was stated in a letter sent in to the Planning Commission, and I'm here to reiterate the points that were made in that letter that you have on file and answer questions. The area around 48th and O is not wanting for off-sale licenses. We are well served currently by the current policy, we believe, and we oppose any changes on the principle of density bringing problems, and we find the current density of off-sale licenses in the neighborhood to be perfectly adequate. And I'd remind the commission, but within a 6-block radius of 48th and O, there are 6 or 7 off-sale licenses currently. If you go south to 33rd and A, there are additional outlets in that area, just outside of our boundaries, but still within easy access distance. The current application solves no problems that currently exist for the neighborhood, and we would submit that it might bring additional problems just from a density factor. Our positions are laid out in the letter submitted earlier, and I wanted to offer the opportunity to address questions if you have any for the immediate neighborhood that is affected by this proposal.
Questions for Mr. Bagby? Thank you very much. Is there anyone else here wishing to testify in opposition to this item?
Hi, my name is Sean Reba, 4411 North Park Boulevard. I just want to go on record by saying I enjoy shopping at Walgreens. I'm also a member of the Open Harvest. I love them. And I also enjoy Zipline beer more than probably most people do. I cannot agree, though, with their stance, however. NeighborWorks Lincoln has been working in a number of these neighborhoods that are going to be impacted by this particular change. We put tens of thousands of dollars into these neighborhoods to help stabilize them. This, to me, would be counterproductive to that. We work very hard to focus on homeownership. We focus to redevelop properties that are falling down. We also help to strengthen neighborhoods by developing resident leadership. So with that said, 100 feet is 100 feet. And like some of the other folks have said, we, again, have worked in these neighborhoods, and we work with the dysfunction that is caused by the density of alcohol outlets. I would love to see any research that shows me that high-density alcohol sales has a positive impact or benefit to communities. You're not going to find it because it's not out there. I've never found it. So anyway, I just want to simply say 100 foot is 100 foot, and I'm just asking you to consider the larger impact of this. We are dealing with the dysfunction and the things that are going on in the neighborhoods to stabilize, and this is not going to help. We have very few tools to help protect neighborhoods. 100 foot is 100 foot. Any questions?
Any questions for Mr. Reba? Thank you.
Thank you.
Is there anyone else here wishing to testify in opposition to this item? Like we're done. Do we have any questions for staff?
I think there's one more.
Oh, I'm sorry.
Hello, just to take a moment, I'm Bob Reeves. I live at 3236 Dudley, and I'm the secretary of the Clinton Neighborhood Organization. And just wanted to reiterate that we voted as a board to oppose this change, and we're really concerned about the proliferation of liquor licenses. And I agree completely with all of the things that Sean has just said. Those are the reasons behind our decision on that. So if you have any questions.
Thanks, Mr. Reeves. Any questions?
Thank you.
Thank you. One more time, anyone else here wishing to testify in opposition to this item? Okay, staff questions? Anyone have staff?
I did. I live in an older neighborhood, and so this ordinance is of interest to me personally, but I was curious when Ms. Payne talked about open harvest, and so they could not sell because they did not meet the length of distance. But then I was thinking of Brewski's, which Mr. Powers brought up at the other end of that development, and I guess I was a little curious how Brewski's got permission and open harvest hasn't, but I'm not sure open harvest has applied.
No, we've excuse me, talked to Open Harvest on many occasions, and I think looked at every possibility we could. The explanation is that the alcohol that's being sold, or the alcohol sales of Brewski's, predates the adoption of these ordinance. So those outlets, facilities, stores that pre-existed or were in existence at the time these special permits were adopted in 1994 get to continue to exist. Even if I own the convenience store and I sell it to you, you can continue to use it. So that's the explanation for that. Where Open Harvest is at, there were no alcohol sales in that bay, in that location, in that part of that larger store. So there were a couple inconsistencies or seeming inconsistencies were mentioned. That was one of them. Another that was mentioned was restaurants. Several of these B2 centers and restaurants in proximity to residential. Recall, though, if you look at the special permits, there's a special, here again, another exception, another amendment to the permits that allows for restaurants to be closer than the 100 feet. Actually, it's 25 feet. Why is that? Well, I think collectively, everybody looked at restaurants and said, well, yeah, it's not this, it's not that, and it's a restaurant. Primary activity is eating, drinking is secondary. And so there's limits on how much alcohol and how much of the revenue, et cetera. And so that's the explanation for that.
I'm going to kind of piggyback off of that. You guys are going to all know I'm not a real big drinker by my questions here. Does Brewski's actually have an off-sale license there, or is it only on sale at that location?
I don't know.
Because that would make a difference as well, correct? If it was on sale versus off sale?
But they were grandfathered.
They pre-existed 94.
But this ordinance is only for off sale.
I don't follow you. I mean, Brewski's pre-exist. whether they have on or off or both, they're there.
Yes, but irregardless, this stuff before us today is only for off sales.
Yes,
Not
correct.
for on sales.
Correct.
Well, I think with it raises another issue for me because and maybe this goes back to the boundary of the zoning. So, you showed how the zoning boundaries cut through blocks sometimes in the older neighborhoods. They're not consistently along streets. And so I look at the Walgreens, the CVS, the convenience store at the gas station, all of those places selling alcohol off sale, and I look at, just specifically Open Harvest in that example, and I wonder, maybe there is room for a reconsideration of boundaries or the small commercial districts to not provide any additional harm. I wouldn't want to limit competition for businesses like Open Harvest, but I also don't want to increase density of alcohol sales in older neighborhoods because, as I think some of the folks said, it seems like newer neighborhoods have more buffers. And so it seems like we might be ignoring something if we let more alcohol come in.
Other questions or comments?
Brian, do other cities have ordinances like ours that are based on the length as the buffer zone, or do they do it a different way?
I've got to be honest with you. I'm not aware of any other city or village in Nebraska that regulates alcohol zoning orders. I'm sure there are some. I'm not aware of any. The State Liquor Commission having that, I asked them that question, trying to seek information about how others are doing it. They were not aware of any.
So, there isn't like a planning best practice as far as alcohol buffer zones or anything that you're aware of?
Well, that's Nebraska. If we look larger nationwide, certainly communities across the country do. They regulate alcohol in a number of ways, either by concentration or by use, or Laramie, Wyoming, where I do have experience, by number of licenses per capita. And so there's multiple ways to do it. Are there other ways we could do it? Probably. I guess what I was suggesting is, in '94, community had a discussion. Yes, Mark Hunsaker can probably tell you more about that history than I can, but after a discussion, these were the standards that were adopted. So, in that 20-some years, I guess I was only suggesting that this is, in fact, it's become the community standard. Are there others that could be used? Well, perhaps, but this is the one that the city of Lincoln landed on, and this is the one that we've had in place for then ever since.
Maya first, and then Lynn.
So I hate to ask you to speculate, but is there any scenario where planning might be supportive of some kind of exception that would support establishments like Open Harvest, Zipline, while being much more restrictive in the greater expense, or is this kind of your shot if you want to?
Well, that's a larger. Let me maybe address the part of that I can. That's a larger policy question for the department that I can't answer. What I can tell you is that previously, when the provision was part of the special permit, that the city council could adjust that separation to something less than 100 feet upon recommendation of the planning director, that adequate mitigation was provided. It set up for multiple problems. There were multiple issues with it. And like I said, fairness was certainly one of them. Equity among licensees and people seeking special permits. It's not necessarily staff was in an uncomfortable position. It's that I think the people who were applying for those permits were being affected, and I think complaining of unequal treatment.
If you had to choose, again, I'm asking you to speculate, and you may not want to, but if you had to choose between the waiver process that you had and the 50 feet separation, what would you choose?
We're recommending denial of that. I'm not choosing either one of those.
If it's a compromise.
That's for the planning commission. This is, I think, our review and our consideration. Like I said, the position we were in with considering individual waivers, I think just proved itself to be unworkable. There was no way to be judicious and equitable across the board in all cases. And I think city council nor staff like being in that position. And so what our review of this one here before us today, I think we stand by that. I think we've laid out, if we're going to have a special permit, which has become the standard, we have that.
Lynn?
I was on the planning commission back then for about 3 months at that time, but I do remember it was a constant fight with every application that came through, and the waivers and this ability to mitigate things just did not work. I thought it was a problem. But I'm curious as your comments on the 100 foot from the front door, bending around.
Well, what I'm saying is that standard applies to the B2 and B5, and I think the amendment at that time to apply it to B2 and B5, the rationale was because, look, these centers, B2 and B5, they're different from the other commercial districts in town. They're different than Union, Havelock, and Bethany. I mean, look at them, right? They've got a buffer surrounding them, oftentimes surrounded entirely by arterial streets, Prairie Lakes at 84th and Highway 2. So that, I think, was the rationale for using that. There's buffer, there's screening, there's landscaping, there's building orientation, all of these things built into it. I would suggest that amendment wasn't initiated by staff. That was brought from the outside, taken through planning commission, city council. I think everybody looked at it and agreed, given those circumstances, it was appropriate.
I guess, and just some of the opinion I'm getting on this is I find it hard to believe that alcohol sales at the Walgreens that's being talked about here, Open Harvest, can hurt anything with the separation that they do have, and I just don't get the connection.
I got to tell you, I've met with, I don't know, dozens of people over the years, and I have met with some who've been very sad. I mean, turned away, finding that they didn't meet the requirements, couldn't apply for the special permit. It is what it is. I mean, we have adopted a standard. So now, do we need a different standard? Are we going to? That's not for me to decide. But given the standard we have, it's applied equally across the board. So what it results in is some places that do qualify and some that don't. What I'd suggest is the other side of it. You look across the city. There are no shortages of sites that sell alcohol. I mean, or qualify for a special permit. I mean, we've granted literally dozens of special permits for on and off sale alcohol. So it's not that there aren't any locations that meet it. There are some that don't. But I think there are those here that would argue, well, that was the intent of it. So
I'm going to follow up. Going back to the potential of some sort of a waiver process. I'm not asking you to speculate, I just have a question. Not specifically for you, but just to think about. It seems to me that, I mean, I understand the need to do things the way we have done it. I mean, I get that, and I understand Lynn's experience. I get all that. We need to keep it equitable. But it seems also that there are, even today, a few instances where it would be beneficial to be able to have some sort of a waiver process to go through, maybe with criteria. I mean, it wouldn't happen often. Is there a way to structure some sort of a process that could get at these special cases so that the overall goal here, the greater good is achieved. I mean, I'm in fully supportive of that, but have the ability for these very unique cases to have a way to go through a process with testimony for and against, get it out in the public record, but deal with it.
Yeah, I mean, if you're asking me, yeah, is there the possibility, is there a way? Of course. Yeah, I mean, sure. That's a decision for,
And that.
right.
I
But
guess
yeah,
I'm
I
just-
mean, well, you can visualize in your mind, looking at other special permits that we have, that there would be some way to craft something that would allow under certain circumstances, some waiver or some adjustment.
Maybe
to be-
pre-qualify or something, what those circumstances could be. But I just wonder about that, just to get it in the minutes.
David Carey with the Planning Department. I sense that there's some ideas here of might be other options in the future moving forward. I would suggest that what we have today in front of you is this particular item that has come forward to us that we need to act on. I would also suggest that some of what the suggestions are topics that need a lot more thought, perhaps even a formal process, similar to what was done back in 1994 that got us to the point with the policy that we have today. So I would suggest that we wouldn't want to jump to a change in that policy without a similar process to get to something.
I agree with that.
I agree.
So
I agree with that.
I just want to put that in the record as well
Yep.
as we
Yep.
have this discussion.
Any other questions? Thank you. Applicant rebuttal.
Mr. Chairman, I think it's been suggested that you might exercise some discretion on a regular basis here, and I think that's true. The excuse of inconsistency as it relates to special permits is a pretty lame excuse. You exercise discretion on those permits every time you meet. The standard for restaurants is only special in districts other than B2 and B5. The Asara example that I showed you, where there's an outdoor patio where they serve food and alcohol probably 50 feet away from a residence, there's nothing that would prevent that from turning into an off-sale store. There's also nothing that would prevent it from turning into a sports bar where they would bring televisions out under the awning and have outdoor sporting event watching and drinking. Back to the reason that I initiated this application at 48th and O, we have, as I said, 65 feet from the building to the property line and a 10-foot retaining wall with residential sitting up above the level of this lot. What is it in that circumstance? What goal of having a 100-foot setback is not met by that circumstance? It is absolutely incredulous that you can't make an exception. Yet the city council and the staff have continued to resist any sort of exercise of discretion because it's easy. They don't have to work at it. They don't have to think about it. It's the comment from the Witherby neighborhood, or maybe the wrong person, Sean. 100 feet's 100 feet. You meet it or you don't. Too bad. Without any thought as to whether or not it's an appropriate use at the location. So we're here to ask you for a leveling of the playing field between some of these districts and the B2 and the B5. We'll try to answer any questions you might have.
Questions from Mr. Hunziker?
Thank you.
I'd entertain a motion.
Move denial.
Second, Cornelius.
Discussion?
Sure, I'll go first. This one's really tough for me because I do think that we're having some nonsensical results as a result of the way the ordinance is written. But as for this particular application at this time, I think, the policy is working the way we want it to. It is a protection for the neighborhoods. What I would like and support is Mr. Carey's suggestion that there be further study of this ordinance, because I think that there should be some ability for waivers with standards. I don't want to go back to where, the waivers start to cause huge problems and are in themselves arbitrary like this policy is. But I think there should be a way that we can have a committee structure or some people really studying this where we can come up with standards. For example, if you are a grocery store and you meet certain other standards, you would be eligible to apply for a waiver. And so I would like to see the city look into possibly a deeper analysis of the ordinance, but at this time, I'm not going to support changing it.
Others?
I agree 100%, and that's almost identical to what my response to this was. I think what we're seeing is the current ordinance generally is effective and has the results that the neighbors would like to see. However, it also results in inconsistent or even contradictory results, which are undesirable. And I think trying to address that with a sweeping change, which is really addressed at one site, is not really appropriate. And what I would prefer to see is a general revisiting of the question, because, for example, there are qualitative differences between the local natural foods grocery store that wants to sell local beer and the place on the busy street that happens to be one half of a block that's also in a residential neighborhood that wants to sell 36 packs of whatever light. I think those are qualitatively different and deserve different considerations. And those are the kinds of things that we'll have to think about. I think, we've got people here today who support this motion for denial, who would say it would be okay for Open Harvest to sell beer, but we have what we have. And instead of trying to fix that with some strike-throughs with the current ordinance and some jiggling around of the numbers, I'd rather see a comprehensive effort to revisit the question and come up with something that we can feel comfortable covering the entire city with and not worry about the unintended consequences. And I understand that we're here today in part because this ordinance, which was apparently drafted by a trade organization, had unintended consequences.
Others? Maya?
I agree with everything that's been said too, and I really appreciated Lynn's input, and it goes to show that we will have a big hole to fill when 3 commissioners go off and all that experience goes away. But I think we all ask these questions because by voting to deny, we don't want to close the door on establishments that bring and add value to the neighborhoods where they are and the community as a whole. So I'm going to also vote to deny, but with the hope that we'll continue this conversation and hopefully find a way to have our cake and eat it too.
Anyone else? Dennis?
I'm going to vote to deny as well, but I want to point out another issue with this particular site, and that is the vertical distance that Mark has alluded to a couple times. I think the ordinance only addresses horizontal distance, but there could be times in the future, or maybe even now, where there is a vertical distance, either with topography or building floors or something, where I think it just points out again that if there was a way to look at this more comprehensively and maybe come up with something that's a little smarter than what we have now, it'd be a really good thing.
Anyone else? Lynn?
Ironically, I agree with a lot of the things that have been said, even though I'm not going to support the motion. unintended consequences are not a good thing. And one of the unintended consequences of what happened here is I don't think that, or what the ordinance as it stands, is that the issue with alcohol-related businesses comes out the front door. And what we have on the books right now does not necessarily address that very well. In concept and the way this is written, where it's saying 100 foot from the front door, I like that idea. And I think it makes sense. But here again, I'm not going to support the motion, but I do support the greater thoughtful process.
Ken?
Well, I was going to agree with what Dennis said, and then also I was going to say what Lynn said. So I do think this is too sweeping of changes. We can do this a little bit smarter, I think.
Anyone else?
I am sympathetic to Walgreens and to Open Harvest, but I think that a change that incorporates the whole city is just not wise at this point. But I do also want to say that there are big differences between on sale and off sale and a restaurant selling alcohol as opposed to just, having a bar. And I think that some of the examples given today were examples that would not apply for this particular situation, and we need to make sure that we're looking at the right ones.
Sandra, anything?
I would just say that I am going to vote to deny, but I really think there needs to be a bigger conversation about this, because I think that there's many small exceptions, and instead of making one blanket change today, and certainly as the newest member, I'd like to beg off for a little bit more research.
Good call. I'm going to support to deny as well. I think there needs to be a comprehensive standards adopted, and hopefully we're moving towards that. As we've talked about, the unintended consequences of this throughout the city is what I'm really concerned about. Jerry, please call the vote.
Okay, the motion is for denial of text amendment number 16013. Cornelius?
Yes.
Core?
Yes.
Harris?
Yes.
Voss?
Yes.
Sunderman?
No.
Washington?
Yes.
Weber?
Yes.
Shear?
Yes.
Hove?
Yes.
Motion carried 8-1.
Want to take a 5-minute break?
Yes.
We'll take a 5-minute break.
That's quick.
go. Jerry, do you want to?
Okay, continuing on with, under continued public hearing and administrative action, item 5.1, change of zone number 16023 from AG Agricultural District to H3 Highway Commercial District on approximately 2.62 acres, more or less, on property generally located at 6625 Northwest 48th Street. Staff recommendation is for conditional approval. Are there any ex parte communications to be disclosed on this application?
I see none. Tom?
Tom Chaka, planning staff. This application is for a change of zone from AG to H3 on approximately 2.6 acres. It's located up off of Northwest 48th and Highway 34. There is currently H3 zoning to the east and to the north, on the north side of the highway. There is AG zoning to the west and the south. There's two parts. One was an oversight in a previous change of zone that eliminated a little strip through here, so part of this is to fix that. The other part is to add this little over 2 acre piece to the H3 zoning. The proposed area is also bounded by a minimum flood corridor on the west, and there's an existing drive through here. There's also a, what used to be a house that they are using as an office for the mini storage. That would bring that office into compliance under the H3 zoning. Currently, it's not allowed in the AG zoning district. This area is outside the city limits, and there are no city services out here. No water or sanitary sewer. The applicant has informed us that the intent of this would be to expand the mini storage use to include in this new H3 area. As part of this change of zone request, planning staff has requested that a conditional zoning agreement be attached to the change of zone. The agreement would address issues to plan for future development and access in the area. The owner has indicated that there possibly would be dividing the larger parcel up into 3 lots. Each of those lots would be over 10 acres, so it would not require a final plat. They could just do that by survey and deed. And so there would be no review through planning department or no requirement for any type of street network or access. Let's see. In the agreement, there's basically 3 requirements of the agreement. One is for a 66-foot common access easement. I think there's a better picture of that. The 66-foot common access easement is here, would be basically this existing road right through here, this existing driveway. Another requirement would be a 30-foot public access easement through this existing road here, or existing drive, I should say, through here. These access easements are being required so that in the future, if, I'm going to flip back to the southern map. Let me zoom in here. So these access easements are being asked for because if these are broke up and sold off to separate owners, if say Lot 2 wants to develop, he doesn't have access except through this access easement. If Lot 3 decides, well, I don't want to give access through here, where is Lot 2 going to have their access? There is Highway 34, but that's under state control, and you'd have to get access approval through the state. And also, it's within the city 3 miles, so the city Public Works Department would have say-so in that too. They do have an existing access to 34 today, but I believe that is just for their soil excavation permit that they have on that property for access for the trucks to come and go. The same with the access easement through Lot 1. You almost need this to access the other 2 lots in the future. The third point of the zoning agreement is that one of 2 access points would go away in the future. Let's see. Currently, there are 2 driveway access points on the northwest 48th Street. These today do not meet the access management policy for access points onto an arterial. We have in the zoning agreement that one of those access points would be eliminated following a determination by the Director of Public Works that the driveway needs to be eliminated due to accidents or to accommodate future development of lots 2 or 3, those future lots there. With that, I'll take any questions.
Questions for Tom?
How normal is it to go to create lots on that 10-acre situation without going through the preliminary plat process?
By state statute, you can, anytime you break up land that's over 10 acres, you're not required to go through any platting process. Is that?
Other questions for Tom? Thank you. Applicant?
Mr. Chairman, members of the commission, Mark Hunziker appearing on behalf of John Zakovic, the owner of the property. This staff report represents very aggressive regulatory overreach, in my opinion. On its face, this change of zone is a no-brainer. The area being changed is the area you see there where there's a gap between the 2 H3 districts that was created by a mistake several years ago, and the area that runs something like this and here. Now, the distance, there's a draw that runs along the west side here and a drainage way that runs all the way down here and then under the road down here. It's 200 feet roughly from that road, and the draw is on the north side of it, to the existing H3 zoning. We're giving up an 80-foot future flood corridor easement or flood corridor along that draw, so call it 120 feet from the flood corridor easement to that H3 zoning that you see there. There's no potential use for that property other than commercial. There is no possibility for that to be developed for residential uses or any other use that is other than commercial. This change of zone, absent these all the smoke that's being blown here about access, is a no-brainer. There are 2 existing driveways off of Northwest 48th Street. They've been there all this time. The purpose of this change of zone is for John to be able to expand his storage business on this property. Storage businesses are notoriously low traffic generators. There is no obligation nor irrevocable plan to subdivide the rest of this property, which, by the way, extends clear down into here, all the way up here and up to Highway 34. It's a big piece of ground. It's a farm. And he has an access point here onto Highway 34, which is not restricted to his dirt mining permit. It is an unrestricted access that was retained when Highway 34 was widened several years ago. We negotiated an unrestricted access there. So we've got two access points here, and Public Works can't even tell us which one they want to eliminate. They don't know. They have no plan for Northwest 48th Street. They talked about, well, maybe it would be better to keep the south one because we might want someday to change Old Woodlawn Road and change that configuration and meet up with the south one. On the other hand, the north one is really kind of too close to the intersection with Highway 34, so we might want to get rid of that one. They don't know. There is no plan, and with good reason, this area won't get services until 2040 or after. 25 years. And yet the staff is asking us to write a blank check to the Public Works Department to give up an access whenever the Public Works Department says they want it. They want a public access easement for the public to be able to get access to our property, which we don't want to give, and a 66-foot access easement for a possible future roadway that nobody knows will ever be needed. We are opposed to all these conditions. We told them in a meeting at one point we would be willing to give up a right to say, you know, if Public Works comes along and has a plan and wants to get rid of one of these access points, we would maybe agree to that. But the rest of this stuff is nonsense. And I really object to the suggestion that this change of zone be approved on the condition that the council public hearing be scheduled after the city receives a signed redevelopment agreement. That kind of leverage is illegal. We have a right to go to the city council for a public hearing. And if you want to check with that with Rick Pale, you can do that because we talked about it. So I think this ought to be approved on its face without conditions because the staff is overreaching and trying to impose conditions which have no business being imposed. We gave up on the minimum flood corridor, which is a subdivision standard, not a zoning standard. It's a subdivision standard, and we are not subdividing. But we did that in an effort to try to get along with them a little bit, but instead they kept pushing for all this stuff, and we're just not going to do it. I'll try to answer any questions.
Questions from Mr. Hunziker?
Yes, I have a question about county CUD. What is a, when I read here, I'm sorry, I'm on the wrong point, pardon me.
Okay.
Any
I'll
other
retract.
questions? Okay, thank you.
All right, thanks.
Is there anyone here wishing to testify in support of this item? Is there anyone here wishing to testify in opposition to this item? Do we have questions for Tom?
Yeah.
Why don't you come on back up, Tom? Tom, do you want to talk about some of the comments that were?
Somebody have a question? Oh. I'll start with the condition that's in the staff report about that a signed agreement has to be done before council hearing. That was actually put in at a time when we thought we had an agreement. We don't have any objection to striking that. As far as the little background on the flood corridor easement, when this first was coming in to establish where the boundary of the H3 would be, expanded boundary, we were looking at what made sense. How far west should this go? And looking at this drainage area, planning was, this makes a pretty good boundary for the extent of the H3. We determined that it was a minimum flood corridor, and if you were doing a final plat, you would show that on a final plat. But since there is no plat being done, we determined show that so we know where the boundary is. The agreement, wanted that more for that. I don't see in the agreement where it says that they have to file a minimum corridor flood easement on here. The easement does, or the agreement does talk about the 30-foot wide public access easement, a 66-foot wide common access easement. Part C is about the 2 driveways. And if you read C, it doesn't say that Public Works can ask for the removal of one of those driveways at any time they please. It says that it would be removed due to frequency of accidents or to accommodate the development of future lots 2 or 3. If there are no accidents, or very few, and lots 2 or 3 never develop, then those 2 driveways points will remain.
Questions for Tom?
I think that's all.
I do.
Glenn?
If we remove the conditions of approval, there's only one there. So are we just approving a change of zone?
The zoning agreement.
City council hearing will be scheduled.
The zoning agreement is after.
I guess I guess my point is that the agreement doesn't have to be signed before scheduling it at council. We would still be recommending approval conditioned on a zoning agreement being signed.
Has the landowner indicated that they're going to subdivide?
Yeah, they showed us, we have an exhibit that showed.
Nice. Future lot, okay.
Future lots 1, 2, and 3.
Anyone else?
Just to clarify, so if we moved approval of planning's recommendation, we move approval of the zoning agreement as it stands, just not the fact that it needs to be signed
Correct.
before the council hearing.
Right.
So it could still be changed then in the council
Council
hearing,
could
potentially.
change it, throw it out, approve it as it is.
Okay. Anyone else have questions for Tom? Thank you.
Mr. Chairman, just one more time. There are no current plans to turn those lots into reality. We have no plans to subdivide. Subdivide, of course, is a term of art, but we are not going to cut this property up at any point in the near future. And John's a farmer, but he's not stupid. He knows that you need to have access if you're going to create a new lot. And so in the event that a new lot would be created, there would be access provided to that lot, and it would have to have frontage on Northwest 48th Street or on Highway 34 in order to be a buildable lot. So the need for the easements that are called for in this agreement is just not there. And as far as the minimum flood corridor, it's only on that plan because we were asked to show it and to use it to measure the line of the edge of the rezoning. We were not doing it because we thought we were having to dedicate an easement, but the planning department wanted us to stop that zoning district line at the edge of what would be in the future someday, whenever it's subdivided 40 years from now, a minimum flood corridor, at least by today's standards. By the time it gets subdivided, it might be something else. But there's absolutely no reason for anybody to want to subdivide this property. There's no water, there's no sewer. It's just not something that it's, when it says future, it means future. We'd ask you to just approve the change of zone.
Mark, I do have one quick question for you.
Okay.
So I understand you might be objecting to the public access easement, but Part B where it says common access easement for future Lot 2 and future Lot 3, you already agree that that's going to be necessary if they ever subdivide out, right?
I agree that there would need to be access provided. I vehemently disagree that it needs to be 66 feet wide, or that it necessarily needs to be in the location that they're showing. We don't know the configuration of future lots other than what's on this piece of paper, which is really not anything other than a concept.
Any other questions?
Thank you.
I'd entertain a motion.
Move approval with conditions, with condition 5 about signing the agreement before city council being removed.
Second.
Discussion?
Well, I always hate it when we don't have everything worked out. But I think there's time to discuss the zoning agreement further. I think there perhaps is not as much distance between what staff is requesting and what the applicant really intends to do with the property. And so I am going to vote approval as per the conditions presented by staff, and hopefully this can be worked out before it's before the city council.
Other comments? I agree with Janelle. It sounds like more of a communication problem, and hopefully between staff and the applicant, they can work this out and figure out what's best for both. Jerry, please call the vote.
Okay, the motion is for conditional approval, striking condition number 5 from the condition, or the zoning condition agreement.
No, it's not 5, it's just this, that it's be signed by.
So that would be condition number 1.
Yeah.
Okay, condition number 1.
I'm sorry if I said 5, yeah.
I heard 5, but who knows?
I probably did say that.
It was 5 in the analysis.
Okay.
Yeah. It's conditions of approval, number 1, that
Conditions of approval,
the agreement
okay.
be signed before it's scheduled before city council.
Okay,
The one and only.
One and only.
right, okay. Cornelius,
Yes.
Core,
Yes.
Harris,
Yes.
Lust,
Yes.
Sunderman,
Yes.
Washington,
Yes.
Weber,
Yes.
Shear,
Yes.
Hove.
Yes.
Motion carried, 9-0. Okay, the next item is item 5.2, County Special Permit Number 16049 for County AG Agricultural District Community Unit Plan consisting of 85.13 acres more or less with 5 single-family acreage lots containing a minimum of 3 acres with a waiver request to block length requirements on property generally located at Northwest 12th Street and West Mill Road. This is final action on this item unless appealed to the county clerk within 7 days of action by the Planning Commission, and staff recommendation is for conditional approval. Are there any ex parte communications to be disclosed on this application?
I see none. Tom.
Tom Chaka, planning staff, handing out a letter I just received here a little bit ago. Property owner located south of the application area in support of the special permit. Just to give you an idea, a little quick mock-up here. This is the application area up here. The owner of this letter lives here, and he's referring to this acreage development over here. I think you all did get emailed another letter from Dan and Cindy Wolf, a letter in opposition to the application. They live right here. And one other thing, basically what they're talking about is that they wanted the lots to be moved further away from their property. So this application is for a community unit plan for 5 acreage lots over on an 85-acre tract. I guess that's as far out as it goes. This is located at Northwest 12th and West Mill Road. West Mill Road here on the south, Northwest 12th's over here. West Mill is a county gravel road. Each of these lots would be over 3 acres in size. They each would have their own septic tank and their own private well. This area in the comp plan is not considered prime farmland. And this was before you, 3 weeks ago, and was deferred. You may have noticed that the site plan has changed from what it was 3 weeks ago. They did, originally the lots were going to be down here. They have moved the lots further north. They're now up on the northern part of the lot. This is a lot for the existing house here. So although there's 5 lots, really there's only 4 new lots. One lot is for the existing house. The applicant is asking for several waivers. All of those waivers are typical for a AG community unit plan cluster development, such as lot area, lot width, etc. Because the zoning is still AG agriculture, which is a 20-acre minimum lot size, so they have to request the waivers to go down in size. Groundwater information was submitted to Lincoln Lancaster County Health Department. They submitted information from 22 wells in the area, and it was Health Department's conclusion that there is sufficient groundwater for these new lots. I think that pretty much covers it. Any questions?
Questions for Tom? Thank you. Applicant?
Good afternoon. My name is Lyle Loth. I'm with Riga Engineering Group, here on behalf of Stephen Muehlbach, the owner of this property.
Give us your address, please.
Oh, I'm sorry, 601 Old Cheney Road.
Thank you.
As Tom indicated, the project that was originally submitted, if it shows up there, does show the 4 new lots clear to the south. And at the having conversations with the neighbors who expressed a desire to have them moved a little further from their residences, we did do that, and this is now the project as we have it today. Please note that there's significantly more road being built with this layout. We're adding 1 additional culvert at the very north end, and so there's quite a little bit more expense with this layout, but the applicant is happy with that and is willing to meet the neighbor's request. So the only other thing, I know there's a lot of talk about the water situation there typically is in these areas, but the health department has signed off on it, and we did get this well information from Department of Natural Resources. And I've said this before on other projects, but domestic use on these types of developments is really fairly minimal. In fact, I'm sure that the James Arthur Vineyard to the north of this probably uses quite a little bit more water than will be required by these 5 homes. So we are in agreement with all of the conditions of the staff and would ask that you approve it.
Questions for Mr. Lowe's?
So have you been in contact with the Wolves, and as your changes relate to their concerns? And
We did get a call from the Wolves this morning, and they were asking us to reconfigure the lots a little bit further. We really don't want to do that. They would ask that we move these two lots over in this area. And I guess we don't see any real reason to do that. That is a low-lying area. The applicant thinks that perhaps someday in the future that there may be a pond developed there, which would add to the ambiance of the neighborhood. So,
but the distance is a little bit greater in the
Well,
revised site plan?
the distance from this neighbor would be greater if we moved it across the road.
Okay.
It would be closer to this neighbor, and this is the neighbor that asked that we move them there.
Okay.
Other questions? Thank you. Is there anyone here wishing to testify in support of this item? Is there anyone here wishing to testify in opposition to this item?
Good afternoon. My name is Bob Hackbarth, 2022 West Mill Road, Raymond, Nebraska, and we are the other neighbor, the one on the west side that adjoins this potential project. I'd like to start out by saying I was a little confused at first because we did have two different site plans. The one on the website was the original one, and one I was handed after the last meeting when it was deferred, which is the current one. But I had no indication whether this was an official change or whatever. There was, no type of stamp on this or anything that said it was from the Planning Commission. So I received that from Marcia Kinning from Riga, I believe it's pronounced. So, okay, thank you. Anyway, I would like to start out by saying that I really appreciate Mr. Muehlbach's, both Harry and Steve. They're willing to talk to us and to hear our concerns, and I think the new revised site plan addresses a lot of our concerns. We share a quarter-mile property line with this proposed project. My two main concerns with this revised one, because they do address a lot of the concerns about proximity to the new structures, houses, and auxiliary buildings, which helps us a lot. But my other two concerns were, number one, water. When they did the water plan here, let me see if I can find that. I got it. Oh, the water test data. They did 22 wells in our area, but we are closest to this project, right on the other side of the fence. And our well data was, not included in this data. I don't have a clue why, but I brought that up to Marcia Kinning again after the last meeting, that probably an oversight. But if you remember a few years back, we had a real problem with dry summer and dry fall. A lot of people not too far from that area were having to re-drill wells or having the well companies come out and lower their pumps in their wells at fairly substantial costs. Currently, we've had enough water. We haven't had an issue. My wife and I, there's just two of us, very minimal water users, but when you're out in the country and you're out of water, you've got nothing. So that is a concern. I do appreciate the health department looking into that, and hopefully their data is correct. The other concern I have is the setbacks. According to Tom, who I talked to a couple times on the phone, the 50-foot setback is for the residents only, the occupied building. That does not include auxiliary buildings, for instance, metal sheds. One of my concerns is they are allowed to put up a metal shed of pretty, out in our neighborhood, a 60 by 100 is nothing. We have 100 by 200 foot buildings out there. 14, 16-foot sidewalls. I don't think it's appropriate to allow one of those within 10 foot of our property line. Everybody that moves out in the country's got to have a metal building, just the way it is. Talk to Morton, talk to Cleary, they do great business. Everybody's got to have one. So my concern on the setbacks, I think with the lengths east to west of the lots, that more than a 50-foot setback for the residents, more than a 10-foot setbacks for auxiliary buildings would be an appropriate modification of the request here. I would like to suggest that no building be built within 100 foot of the property line. Most of the lots are over 500 foot deep. That still gives them, 400 feet between the front of the property to the rear to put whatever buildings they choose to put, without infringing on their rights to use their property as they see fit. I think that's a reasonable request, and I believe with those, this new revised plan would meet most of our objections. The only other thing I would like to mention before I'm done here is, if you look at the area out there, there are 4 clusters that I'm aware of small acreages, 3 to 5 acre places within there. Mr. Mushik's over there on North 27th, south of Mill Road is one of them. Willard Estates up on about 34th and Raymond Road, 30th and Raymond Road is West 30th and Raymond Road is another one, but that's been there for a long time. Everything else in that area is either large farms or 20-plus acre properties. So, you know, this is a change. It's not a change that I'm completely objectionable to, but people that live on 3-acre places have a different lifestyle than people that live on bigger parcels. It's just, it's not good, it's not bad, it's just the way it is. And I would like to keep the integrity of the area as much as possible. So again, I guess I'm in the middle. I'm not completely opposed to the plan, and I do appreciate the changes, but I do have some concerns. Questions?
Mr.
anyone?
Heckbar? Any questions? I guess so. Thank you.
Okay, thank you.
Is there anyone else here wishing to testify in opposition to this item? Do we have questions for staff? Tom? Anyone? Okay. Applicant rebuttal, anything else, I guess? Anything else? Nope. Okay.
Can I ask a question of the applicant?
Sure.
I'd like to know what the applicant thinks of the suggestion to set back auxiliary buildings to at least the minimum distance that residential buildings have, or to increase to 100 foot.
We would definitely not be in agreement with increasing the setbacks. In general, I guess we would just as soon leave the setbacks the way they are. That's the way all other acreages have been developed and created, to my knowledge. And I guess I don't see any real reason that we should change that. Admittedly, we are on fairly large parcels of ground, but when we're dealing with septic systems, that can sometimes create some situations that you don't have access to all of the property, and you can't be real specific as to where you actually build any outbuildings you might have. Okay?
Other questions? Thank you. I'd entertain a motion.
Move approval. Lust.
Second, Core.
Discussion. Anyone? I'm going to support the motion. I appreciate the comments that Mr. Heckworth brought forward. Hopefully he can work those out with the owner of the property. And Jerry, please call the vote.
Cornell, yes?
Yes.
Core?
Yes.
Harris? Yes. Lust?
Yes.
Sunderman?
Yes.
Washington?
Yes.
Weber?
Yes.
Shear?
Yes.
Hove?
Yes.
Motion carried 9-0. Again, this is final action by the Planning Commission unless appealed to the county clerk within 7 days.
Okay, at this time, the Planning Commission will take action on the 5 following items carried over from the November 9th, 2016 meeting as a result of the motions not obtaining a minimum of 5 affirmative votes. Please note that the public hearing on these items is closed and the discussion should be limited to questions of the Planning Commission members for clarification purposes only. Jerry, please call the first item for Planning Commission action only.
Okay, item 6.1A is comprehensive plan amendment number 16001 to amend chapter 5 of the 2040 Lincoln Lancaster County Comprehensive Plan to remove the reference to Lincoln's theater policy. Staff recommendation is for denial. Are there any ex parte communications to be disclosed on this application?
I see none. In order to bring this forward, I think we need to entertain a motion and bring it forward, so I'd entertain a motion at this time.
Move denial.
Second, core.
Okay, now discussion.
I'm going to just reiterate some of the comments that I made when we had this vote previously. For me, it's the main reason I'm voting to deny today is that when you look at it from kind of a risk and reward ratio or situation you have, we know there is some potential for risk with to downtown businesses, entertainment in particular. If a big movie complex would go in somewhere close to a residential neighborhood with lots of parking, and it would arguably take away some of the visitors from downtown, and that would have an effect on other businesses as well. If we had something in front of us that that proposed an actual project that could act as a catalyst for another part of town, and I'm not going to speculate about what that would be, but I would think I would look at it differently and say, does this bring enough reward to impose some potential risk in downtown? And since we don't have an attached project today, I agree with planning that we don't need to make this decision right now. I think the protective policy has served a purpose. It does to some extent limit the consumer's choice, and I do care about that, but at this point I see risk without real reward, so I'm going to move to that.
Others?
Yeah. I'm not changing my vote from the last vote either. I'm going to support denial, mostly because this is a policy that's worked. We have been able to have additional development in the downtown with the theater as an anchor down there, and I think we even saw another project today that's near where the Grand Theater is, I think this policy has been a catalyst for development outside of the Haymarket area and into the rest of the downtown area, and I don't see a reason without a project before us to change a policy that has worked for us for several years.
Anyone else?
Yeah.
Go ahead.
Ken?
I'm not going to support the denial. There may have been a time when this was first initiated that it made sense, but I think now enough time has passed, and I'm just not comfortable with a policy that protects one entity over other businesses, and I think that we need to let the marketplace play it out, and I don't really think that removing the policy, in my opinion, is going to affect that much at this point, because it is partially built out downtown now, so I don't plan on supporting the denial.
Len?
You know, and I'm not going to support it either. The one item I've been hearing is, and I've thought about too, we don't have a proposal to compare this to. But how can you have a proposal and still respect the amount of money that the current providers have put into their facilities, expecting things to be the way they are? I like the fact that this has a sunset in it, 2022, I believe it was. And I like the fact that the market studies is still a component of it, which could help address any adverse effect that multi-screen theaters outside the area could affect the downtown area.
Anyone else? Michael?
I was absent 2 weeks ago when this was initially heard, but I reviewed the testimony and I, of course, went over the minutes. And I tend to agree with what Commissioner Harris has said so far. We've got a kind of a chicken and egg problem. We want to remove this policy, which has resulted in positive outcomes for reasons of principle. And in general, I agree with those principles. However, what we've seen is that this policy has been beneficial, has had positive outcomes, and we don't have examples of positive outcomes to support removal of it. We don't have a proposal in front of us which we can review and weigh on its merits, whether it will have positive or negative outcomes. We only have the request to, or the proposal to remove this policy, which in my opinion has been beneficial. The reason it exists is because it's very easy to leave downtowns to atrophy. And we have been very successful as a community in supporting our downtown and keeping it vital, and I'd like to see that continue.
Anyone else?
I'm going to support the denial because I think that downtown, this part of downtown still needs that protection for a little bit longer. So I think it's important to keep that in place.
I'll just mention that I'm not going to change my position from the previous vote, so I will be supporting the denial as well.
Anything else? I'm going to vote against the motion. I think that been thinking about this a lot for the past several weeks. I actually wrote some notes down. I'm glad we now have all the Planning Commission members here to vote on this item. I support removing the Lincoln Theater policy with a 5-year sunset, which gives Marcus Theaters time to react to the eventual removal of the policy. Back in 2004, the Lincoln Theater policy was helpful in convincing Douglas Theaters to make significant investment in the 14-screen Grand Theater in downtown Lincoln. But the fact is, prior to the Grand, there were 5 successful theaters operating in downtown. The Douglas 3, the Lincoln 3, the Plaza 4, Cinema Twin, and the Starship 9, which was a second-run theater, which totaled 21 screens. Downtown Lincoln has had a very successful theater business for many years, and given the fact that the university continues to grow and house more students, and downtown housing continues to increase at a rapid rate with all the new apartments and condominium projects, it's hard for me to imagine that a downtown theater will not continue to be successful. Marcus Theaters has owned all the first-run theaters in Lincoln since 2008. They've done a good job maintaining and upgrading the theaters for those 8 years, but the fact is Lincoln has grown by 23,000 people in that time. This increase in population should justify and support easily a 6-screen theater. Think about Kearney or Fremont or Hastings, which all have around 23,000 people, and they all easily support more than 6 screens in their city. Marcus Theaters has not added any new screens to Lincoln, while the population of Lincoln has grown over 23,000 people. Consider North Lincoln, north of our street. I'd estimate the area contains over 100,000 people, yet there are no first-run theaters in that area. The Grand and East Park are at the edge of this area, but North Lincoln is not being served. The fact is, it is not financially feasible for another movie company to open a 6-screen movie theater in North Lincoln. The only company that can do this is Marcus Theaters, yet they've not done so. So those movie patrons must travel further to see a movie. In my opinion, the Lincoln Theater policy is a protective policy that prevents open competition. According to our speaker from Marcus Theaters several weeks ago, he knows of no other community in the country that has a theater policy like this. That may be because the policy is anti-competitive. Since there is no one asking to build a movie theater at this time, this is the best time to set a sunset in the policy so that the investment that Marcus has made can be recovered. Waiting until another movie theater company contests this policy will force the city to either eliminate the policy, thus forcing Marcus to immediately change and forfeit some of their investment, or not ever change the policy, which means Lincoln continues to grow and many more areas will be underserved. Jerry, please call the vote.
Can I ask just one clarifying question before I do that? I think when we had this 2 weeks ago, or there was one portion of it that we were voting to approve, the smaller theater one. So I just want to clarify what the motion is doing.
I think right now you have called the comp plan amendment item
Okay,
That is correct.
all right,
First.
So
okay,
that, we'll do the text amendment
next.
separately.
Okay,
Yeah.
all right.
Jerry, please call the vote.
Okay, this is for denial of Comprehensive Plan Amendment number 16001. Cornelius?
Yes.
Core?
Yes.
Harris?
Yes.
Lust?
Yes,
Sunderman?
No.
Washington?
Abstain.
Weber?
No.
Shear?
Yes.
Hove?
No.
Motion carried 5-3 with 1 abstention. Next item is item 6.1B, text amendment number 16006, amending the zoning ordinance to allow theaters as a permitted use in the B5 zoning district after January 1st, 2022, and to allow theaters with 250 seats or less as a special permitted use in the B2 and B3 zoning districts. Staff recommendation is for conditional approval. Are there any ex parte communications to be disclosed on this application?
I see none. I'd entertain a motion.
Move approval.
Is there a
approval or
second?
denial?
Of the text amendments with the 250 seats, yeah, approval.
Second, Washington.
I could
Yeah,
provide
why don't you, can we be
clarification
more
if you'd like.
the motion?
Yeah. So the applicant's proposal is kind of two pieces to the zoning code. One is to add smaller theaters to the B2 and B3 districts, and then also remove the conditions for theaters in B5, which would also eliminate the maximum number of 6 screens. The conditional approval from staff says that we would support having theaters in B2 and B3, but to leave the conditions and special permit in B5 as is.
How did we vote on it last time? I mean, what was the motion last time? Was it denial except for?
I think it was conditional approval.
Conditional approval as per planning's recommendation.
I'm looking
I
at
think
the
that was
minutes
correct.
just a
Yes.
sec.
Yeah. So that's my motion.
I'll wait for Jerry to look that up.
Can I ask a clarifying question about the motion? So conditional approval would, the staff would say, yes, approve B2, B3, change or strike the B5.
Staff's recommendation would say to allow the smaller theaters in B2 and B3,
Okay.
but keep everything as is in B5. So you'd still have it as a special permitted use. You can have no more than 6 screens, no more than 1 theater per district. All of those conditions would still remain.
All right, leave 5 unchanged.
And so your motion is for staff recommendation.
Correct.
Do we have a second on that?
I'll second.
Okay. Discussion? Jerry, please call the vote.
Did you want further clarification in terms of the motion made at the last meeting?
Yeah.
Okay. Just reading through the minutes, the initial motion was for conditional approval as recommended by the staff report. And then after some discussion and clarification from Rick Peo, basically Hove said that the motion is for approval subject to the staff recommendations. Harris confirmed that that is the motion that she seconded.
So I made you
So
have
it
this
is.
same conversation twice, I'm sorry.
Please call the vote.
Cornelius?
Yes.
Core?
Yes.
Harris?
Yes.
Lust?
Yes.
Sunderman?
Yes.
Washington?
Yes.
Weber?
No.
Shear?
Yes.
Hove?
No.
Motion carried 7-2. Okay, the next item, before I call the next item, actually, I wanted to note that staff provided 4 memoranda to the planning commission members regarding the next 3 items, including revisions to the conditions of the use permit, all of which have been distributed publicly and made part of the public record. Okay, the next item is item 6.2A, Comprehensive Plan Amendment number 16004 to revise the future land use map in the 2040 Lincoln Lancaster County Comprehensive Plan from public and semi-public and residential urban density designations to commercial designation on approximately 34.38 acres, more or less, generally located at the northeast corner of South 14th Street and Pine Lake Road. Staff recommendation is for approval. Are there any ex parte communications to be disclosed on this application?
Any
Beyond the
Beyond
last
what we
meeting?
last
I
disclosed?
mean, we disclosed
Any
last time.
further?
Okay.
Any further?
You know, I will say I had general conversations where people asked about it, but I didn't encourage it, and none of them went to the extent of me telling them to contact planning.
I'd say the same thing.
Yeah, me too.
Ditto.
Okay, thank you.
Okay, to get this on the table, I'd entertain a motion.
Move approval, core.
Second? Shear?
I had a clarifying question about one of the memos.
Are we on the comprehensive plan amendment?
No.
Why don't we discuss it all together, if that's
Yeah.
okay?
But that's, we're
Yes.
moving that one, okay.
So the memo on the traffic study, I have a question
Rachel, do you want
about
to come
it.
up? Okay.
Hi, Lonnie Berkland, Manager, Traffic Engineering Division.
So this is on memo number 4, where we compared different traffic generation scenarios. And
Yes.
we found that the Costco would have less traffic generation than illustrative concept A or B. And my question is to illustrative concept A, that includes a 52,000 square foot box store as part of the development, right?
Yes.
Okay, so we're comparing then Costco to another big box development with smaller commercial development around it.
Yeah, I think the illustrative concept that Rachel had put together, which is this one I think you're referring to, basically showed a smaller 50,000 square foot footprint of probably a typical discount store of some sort, and then what we would refer to as probably specialty retail uses for the gamut of it. And the trip characteristics for that concept were somewhere in the neighborhood of around probably 20% higher from a daily standpoint, but they were nearly identical during the PM peak hour, which is kind of the critical peak. So pretty similar during the peak hour conditions.
Thank you.
And you're not suggesting that a light be installed at 16th and Pine Lake, is that right?
No, we are in agreement with the applicant's traffic engineer that recommended 3/4 access at 16th Street and a full signalized intersection at 20th/Hazel Scott.
So the only stoplight on Pine Lake would be Hazel Scott?
Yes, that's the only one that was shown to be warranted in the applicant's traffic study, and we're in agreement with that.
And 16th was left in, right out.
Yep, would be right in, right out, and left in off of Pine Lake. It would just eliminate the left out movement, which was what would be the conflict.
Okay, and clarify the one that's on, going onto Hazel Scott Drive, where people leave, I just want to make sure I have it right.
Sure, yeah.
Leaving the complex or the site onto Hazel, you can only go right. You won't be able to go left.
Yeah, I think the attempt, the design, and actually they might have a graphic of that, but I think the intent was to try to eliminate left turns out from that drive that would proceed back north through the neighborhood, and also to disallow right turns into that drive from the north from the neighborhood.
Are you talking at Hazel Scott out of the complex or at Hazel Scott and Pine Lake Road?
No, what he's talking about
Okay,
there.
gotcha.
Just on Hazel Scott.
But there's no median there, is that right?
Yes, you are correct. So it would have to be signed as right turn only, and there would be some unique geometry to that driveway to attempt to make that happen. But, yep, you're exactly right. And I think they have a concept of that if you're curious to see that.
That's
Okay.
fine. I just wanted to check that out.
Anything else?
Any other questions?
Can I ask questions that are clarifications that are not related to the new information? Can I still ask a staff question?
I think not.
No.
Any other questions?
I have a question for Rachel.
Thank you.
Rachel, I may be misremembering, but in the memorandum number 3, there were quite a few changes there, and then on the last page, under 10B, there's striking the word similar and changing it to compatible with.
Right.
I thought I remembered when we last discussed this, the planning didn't like compatible with because it was too open to interpretation. So how do you find yourself changing your mind on that particular?
So you're correct. That's what we had previously said, but as part of this effort to come to a better agreement with Costco, we determined that we could live with that condition given that they agreed to our other design standard conditions regarding the facades of the buildings.
So could you give me a concrete example of something that language changes? You know, in terms of, is it the building material or is it the general look of the building, the colors? What does the language change in practicality?
It discusses this change relative to building materials and colors, both.
So how much does it increase the range of what's been proposed in terms of the natural
change.
stone and brick versus imitation and so
Well,
on
so
and so forth?
that's a separate sub.
Okay.
Part of it, the requirement about the minimum percentage of brick or stone, Costco agreed to that condition, and this is another sort of sub-bullet under that design standard. And it wouldn't necessarily refer just to like masonry or some other kind of building material. It relates to color. I mean, it's hard for me to say. It's pretty subjective.
Are there other buildings in that area that have similar design standard or designs, or without windows, or without with the metal that is on these buildings, on this building?
Can you repeat the first part of it? Are there other buildings
buildings
in
in this neighborhood that would have no windows or no metal, or that would have metal?
So, I'm going to try to answer as best I can. We have, like I said previously, we have other centers in Lincoln that have design standards unique to their centers. They're all different, but I would say, I mean, most of them regulate facade materials. That's one of the biggest, most common elements of those design standards. I can't recall the details of them, but a lot of them have a minimum percentage of stone or brick. That's typical.
Okay.
Does that get to what you're asking?
Can I try to get to it a little bit? I don't want to put you on the spot, but if you were an architect, for example, could you compare the standards that we're asking, that the planning department is asking Costco to follow, could you compare the effect of those as opposed to the Shopko building that's just a little bit east at 27th and Pine Lake, in terms of materials?
About whether they would be considered compatible with versus similar to?
Well, that'd be a good place to start. For example, would the Shopko at 27th and Pine Lake be compatible, as you're defining compatible, on the site where that we're looking at for Costco?
I probably can't answer that question.
Okay.
Is what I think, because the way it will actually be evaluated is that an architect
right
would submit a letter certifying that it meets these requirements. And I believe that would take place at the building permit phase, and I believe there are others, not myself in the office, who conduct those reviews and review what's submitted by the architect and determine if they agree with it or not. But it certainly does open the door to more disparate designs in buildings than the similar two.
Right.
So could you go over again how you arrived at agreeing to compatible with versus similar to?
Sure. So we're trying to make an effort to meet in the middle on a lot of these, and given that they had agreed to meet the minimum brick or stone facade requirements, we felt like that was really the biggest element, and then this was a smaller piece that could be dropped off.
So is that
and would
mainly
not have a significant negative effect on the quality of the buildings.
So is it mainly a financial consideration, not it
It
being
was not
too
financial,
expensive?
no.
Okay.
No.
Steve Hendrickson with the Planning Department. Maybe it can help. Just specific to your question on this sentence, I think Costco, once we had a chance to talk with them, made it their concern was the word similar versus compatible. And so we agreed their concern was that it would have to be very much the same color, the same exact building materials. What if they wanted to use a different kind of stone? Does similar mean it has to be really that stone? And compatible meant you'd have a little bit more interpretation in terms of, well, this looks to be still compatible with that. It's a subjective term. But given the standards overall, we felt that we weren't looking to have identical buildings one to the next, that compatible was still a very useful term, given that it was a part of the overall building standards. So that's why we agreed to the term compatible with rather than similar to, because we weren't looking to have identical. That wasn't our intent.
So maybe we could say something like it would be aesthetically pleasing. It wouldn't be like a metal outbuilding.
And again, this is just simply that the other buildings in this center would have materials and colors that are compatible with the Costco building. It isn't compatible with other buildings in the area to the south side of the street or the east on 27th. It is talking about how Costco compares to the other buildings. They're supposed to be compatible, not identical. And I think the concern of the applicant was similar meant identical, which was not our intent.
Your intent is to have it, the looks for this area to be compatible. When you say the word compatible, that it's unique. Everything kind of fits together, not necessarily that it has to match what's on the south side.
Yes, and actually the building standards do have, the other buildings have more brick and stone than the Costco building does.
And you're no longer concerned about that being able to be too broadly interpreted?
Well, Costco had requested to actually reduce the amount of brick and stone that might be on their building. They have withdrawn that request.
Okay.
They now agree with the percentage that we had proposed, and as a result of that, we felt that saying the other buildings were compatible was an appropriate term.
So it's a compromise?
Correct.
Were the advanced trail crossings, have those been, what's the action been taken on those?
On the improvements to the trail crossings?
Mm-hmm.
There was no changes made to that as part of these revisions, so those would stay as they were.
Okay, because they had been requested to remove those, but those are staying put.
Yes.
Okay.
I have a question. In the memorandum, I'll call it a compromise. I think that probably is a good term. The compromise on the 100% landscape screen, reducing that, just to clarify for my own sake, was that primarily due to the fact that there will be additional landscape screening on the property north of Costco?
That was one aspect of it, yeah. Another was that they had submitted some specifications on the berming.
Right.
And there's some pretty significant berming, especially on the west side
right. Okay.
of the site. 8 to 10 feet. So we felt like that was a pretty big consideration that could be better accounted for in terms of the screening to help make these compromises.
Okay.
Any other questions for Rachel? I did have another traffic question, if you wouldn't mind. In your study that you put together, you said on a Saturday peak trips was 1,470 trips per hour, is that right?
Yes.
And that's to and from or just one way?
Yeah, that's entering and exiting, total volume.
Okay. So that comes out to like 24 per minute. I mean, if you
Haven't
divide it
done
by
that
60,
math, but
yeah,
sure.
I did it.
Yep, in an hour.
So 24 cars per minute going out, 24 coming in at peak hours on a Saturday.
Mm-hmm.
Can I ask a clarifying question? When you say in and out, does in one trip and out another trip? So is that two, or is in
Yes.
and out one trip?
Yes, nope, that's 2.
Okay.
Okay, so
But
it's
maybe you mean 12 and 12. If you're
12 and 12,
okay.
12 in, 12 out
Yep.
per minute.
Exactly.
Okay.
And that is, so when you say 1,470 Saturday peak trips, that's per hour?
Yes.
Or is that per the whole day?
No, what they had included originally and what was on the tables is there's a daily traffic generation and then an AM peak and a PM peak, and then they had also included an assumed Saturday peak, and that was similar to an AM or PM, but basically the peak of a Saturday day, when worst case peak hour of that generator on a Saturday.
Busiest hour of the
Yep,
Saturday.
exactly. There you go.
The average, or the total is 10,000 trips per day.
Yep.
Okay. Any other questions? Thank you.
Yeah.
Discussion amongst ourselves?
Yeah, my husband's gonna be shocked, but I'm actually gonna change my mind about something. I initially supported the application, but my analysis at the time was that, that this is not a commercial pad site right now. It's an agricultural pad site. And while it has been for sale for a while, the people that have come into the area would not have noticed that this was going to have been developed this way. So generally, I was more sympathetic with the concerns of the neighbors. The thing that changed my maybe initial thoughts to oppose it at the last hearing were that we were told that the strip mall type development that is across the street to the south of us would actually develop more trips per day than Costco would. But when I looked at the trip generation memo that was put together, the assumption under that was that there's actually another big box, not as big as Costco, but at least another big box retail establishment in there was built into the comparison scenarios. So now I don't feel confident in the idea that there's worse options out there. So I am no longer going to support the application.
Others?
Are we discussing?
We're just going to discuss
all of
everything
them?
together,
Okay.
yes.
Yeah, I'll go. I'm going to continue to support what I supported at the last meeting, and I want to reiterate the main points of how I got there. I continue to think that it is really difficult, it would be really difficult for me as a planning commissioner to vote against approval of the plan amendment. I mean, it's just, this is inevitable that this land use is going to change, and I think we need to recognize that. I'm also, as a planning commissioner, it'd be really hard for me to not support the idea that this property ought to be zone B2 when the property across the street is B2. I do struggle with the use permit, and as I said the last time, I think as planning commissioners, I didn't say it exactly this way, but I implied this, we have a certain number of tools in our toolbox to use. And I think that the planning department, with their conditions, have tried to maximize the use of those tools. And I'm comfortable with where we are in terms of screening, in terms of architectural aesthetic. It would be better if the architecture could be better, but I don't think as planning commissioners we have the tools to say that we shouldn't approve it, or we should approve or not approve because of that. So I'm going to vote exactly the same way as I did the last time. I do appreciate all of the additional information, the memos and the traffic study explanation. That's very clear. And I also am very grateful for all of the testimony that we've had. I think it's been very helpful for all of us. But that's how I'm going to proceed.
Others? Ken? Ken first, and then Maya, and then...
Yeah, I'm going to try to keep it short. I agree with a lot of what Dennis said. I appreciate the concerns that were expressed regarding traffic, pedestrian interaction, safety, screening, building designs. It appears that the applicant has worked with planning to try to meet some sort of a compromise on design standards. They appear to have met or exceeded screening standards. For me, that leaves traffic, and not being a traffic expert, I have to rely on our reports from our experts, and they assure us that they can handle the increases in traffic. So I will support the items before us.
Maya?
Go ahead.
Okay. I'm not going to repeat. I think Dennis said a lot of this very well. I appreciate the care and thought going into the design of the building and what they're doing to try and match what's around there or to that same standard. Like Ken said, my biggest thing was about the traffic, and I was concerned about traffic bleeding into the neighborhood down Hazel Scott Drive. I'm comfortable with the solution. I'm comfortable with the project. While this trip numbers sound big, they always sound big, but by the time you put it onto roads that are, in my belief, is built for it, we won't really see much going on.
Maya?
I'm also not going to change my vote. I will vote in support. It's been a struggle, I think, for all of us because there are conflicting interests. And we have a duty to take all of those interests into account. Some of the interests are aligned, like the buyer and the seller, some of the business owners. The community as a whole, I think, wants Costco, wants the goods and services that it provides, and the relatively competitive salaries and benefits that Costco offers. However, this is not something that fits neatly into our comprehensive plan, as evidenced by the fact that we need a comprehensive plan amendment and a zoning change. So I think it's very appropriate to discuss this, and the question becomes, is it so incompatible with the surrounding uses that we vote to deny, or do we try to bring it into compliance, if you will, with the neighborhood by imposing conditions that I agree with some of what the applicant has said, that some of these conditions have been pretty strict, but I do think that they are an attempt to solve those incompatibility issues. And I think with respect to the screening and the landscaping and the design standards, I feel comfortable. The most important issue for me, and I think for most of us, has always been the safety of the kids that attend the schools in the area. And like Ken, I'm not a traffic expert, and I have to rely on the information provided to me that Planning and Public Works are telling me that this can be managed, and that the result may be some manageable congestion at times, but that it does not pose a threat to the kids that attend school in the area. And my vote is as good as the information that's provided to me. So as relying on that information, I feel comfortable sending it to the city council to work out those issues. And one of the important factors for me that we haven't discussed so much is the fact that LPS is not opposing this this proposal. And
I don't think they're supporting it either.
But the fact that they're neutral is, it factors into my decision. I'm going to assume that if they saw a safety hazard, they would oppose it.
Sandra or Tracy?
I would like to explain the vote I'm going to make, because this is my first meeting, and try as I might, my prayers did not.
Trial by fire.
It didn't work, because this issue is set before me here, and I've read all the letters that came in, and I've read the staff reports, and I watched the 5.5-hour meeting, which was just thrilling. Thank you. I was surprised when I first looked at this issue and realized that that area was zoned ag, because it didn't make a lot of sense to me that into the future that we assumed that an agricultural business would continue there. So I'm not surprised that someone's come forward and asked that it be changed to commercial, or whether it was residential or commercial. I'm fine with making the change in the zoning. This is it's certainly a desirable business for people who like to shop in bulk. I'm not a member of Costco, but I can understand why they want to be in Lincoln, Nebraska. My issues in looking at this were to look at safety. My biggest concerns were safety, and I feel very good that the peak hours of business for Costco do not coincide with the peak morning traffic for the schools. And though they are open during the school's dismissal period, that's also not a peak shopping period for Costco. So I'm comfortable that there won't be an immediate conflict between the user groups that are going to be in the area. I'm also concerned that the existing neighborhood not change its feel. And so everything that public safety or Public Works has done to assure us that the traffic flow through the neighborhood can be halted or slowed down, or not, at least not negatively affect, is important to me. Because I think the people who moved into that neighborhood had no idea that a future neighbor could be Costco. And I don't think they should have to suffer a lot because people are looking to cut through that neighborhood. I'm impressed with the amount of screening that Costco has agreed to. The fact that they upped the design standards and have met what we, the city of Lincoln, would like is impressive to me. And I want to thank the staff for being so diligent and making certain that all of those things were done. And I'm going to depend on the staff and everyone else to make certain that they are done, so that when this development goes in, we don't shake our heads in 18 months and go, wow. So I'm going to trust the staff who put a lot of effort into this. And I will vote to approve.
Tracy, anything?
Michael, do you have anything?
Oh,
sure. Well, it's going to be hard to say anything that hasn't already been said. Dennis put it very well when he said that the first two items in this package are difficult to imagine not supporting. So it comes down to the questions that surround the development of this corner, specifically in this way. However, if you take it in the context of the city, I think Maya is right that this is desirable for the city because of Costco's social positions and also generally by consumers, Costco is desired. And I think it's very likely that wherever they chose to site it, there would be opposition on the bases or the bases that we're seeing, that traffic will be an issue, that is it compatible with the surrounding uses will be an issue. Here, the friction is largely with the neighborhoods to the east. But however, if you look at it in the context, the larger context, not of the city, but maybe just this section, we see major retail on the southeast corner there in the form of Shopco. We see a neighborhood slash strip mall, neighborhood center slash strip mall just across the street. We see major arterials in play to handle the traffic, and we've also seen efforts both on the part of planning staff and the applicant to develop in a way that is sensitive to the surrounding area, both in terms of architecture and traffic. And I am inclined to support this motion, or the motion that has yet to be made, the motion that was made at the meeting on those grounds.
I'm gonna follow pretty much exactly what I said last time. I'm not gonna change my vote, and I think I pretty well explained how I came to that vote last time, so I'm not gonna bore you all again.
Okay. I'm not going to change my vote either, and I'm going to vote against the motion. I'm glad we now have everyone here at the Planning Commission to vote on this. I support Costco, but I do not support Costco at 14th and Pine Lake, as I believe it is very short-sighted, and the unintended consequences of approving this will be dramatic. Costco says their location decision is based on space, access, and location. The access to this location is poor compared to other locations, given Pine Lake is a busy minor arterial, and there is not enough space to build a commercial center of this magnitude. The only reason to select this site is location with proximity to higher-end customers. However, most of the neighbors are not supportive and have said so in communications to the planning department. I've counted numerous letters and emails in opposition to this, most living very close to this location. The traffic along Pine Lake is already busy, and this development will only add to that congestion. Costco should not be so concerned about being close to population density as much as easy access and more space. A Costco customer coming from central or eastern Lincoln will have a far quicker and easier trip to get to Highway 77 and West Denton Road or 40th and Yankee Hill than to get down to 14th and Pine Lake. The city, incidentally, spent $4 million in infrastructure for a large supercenter to be located at Highway 77 and West Denton, which never happened, but I believe the ground is ready to go there. Costco is a regional attraction and will bring customers from throughout the city and region. Pine Lake Road is a minor arterial and cannot and should not support regional traffic. 99% of Lincoln is located east or north of this proposed location. Most traffic will use Pine Lake to exit, as 14th Street is very congested and the 14th and Old Cheney intersection is troublesome, where deaths have occurred. It's likely that the traffic counts are inaccurate, as people from Lincoln will really only be using Pine Lake East and 14th Street North. There's nothing south, and you can't go west. I believe we're desperately trying to accommodate Costco by making unnecessary compromises in traffic design standards, and landscaping in order to shoehorn this project into an area that cannot support the traffic and has consistently shown higher design standards. The notion that ingress-egress traffic counts on the south side are greater than the traffic counts that Costco and the rest of the development would generate, I believe, are erroneous. Placing one stoplight at Hazel Scott will not support Costco. It's only a matter of time before traffic counts dictate that a light would be required at 16th Street. I travel quite often to the Super Saver at 27th and Pine Lake, and often when I'm exiting north out of Super Saver onto Pine Lake, heading west, since there's no stoplight, I have to wait several minutes to get onto Pine Lake. We just heard that there's 12 cars per minute going past there now, actually 24 going either way. It's not beyond thinking that an unintended consequence of this move would be that another traffic light will have to be installed at Pine Lake between Shopko and Super Saver. That'd make 7 stoplights from 14th to 27th. Of the 8 intersections that the traffic study has studied, 1 graded a C, 2 graded Ds, and 1 graded an F. 4 of 8 intersections are already stressed. Traffic exiting out of Costco onto Hazel Scott Road will simply have to make a quick U-turn in order to run through the neighborhood and avoid congestion being created on Pine Lake. Further, Costco was asking to eliminate advanced trail crossings. I think that was removed now along the driveways. Those trail crossing signs are really for the safety and security of children. It really is outrageous to me that Costco would be asking to remove those types of things. The applicant consistently called this building a warehouse and is asking for significant accommodations to standards in building materials and landscaping. All the buildings around the South Point have followed specific design standards for brick, landscaping, and windows. If Costco wants to locate in this area near South Point, shouldn't they have to abide by the same set of design standards that those businesses had to follow? If they want to fit in the neighborhood, then they should have to follow the same set of rules. Otherwise, they would be welcome in other areas of Lincoln. Bottom line, this is a large company from out of town throwing its weight around. I don't think that's what we should be doing. I can imagine a Saturday afternoon where Lincoln Southwest has several sporting events as well as a theater program. Scott Middle School is holding a music program and their routine YMCA basketball or volleyball activities, and Costco has bumper-to-bumper traffic in between, jamming up the entire road. The unintended consequences of this development will be enormous. I hope that the experts here today are ready to shoulder that responsibility of this decision, and as it will be closely watched. But what I really hope for is Costco would find a different location for Lincoln. Jerry, please call the vote.
Okay, this is for approval of Comprehensive Plan Amendment 16004. Cornelius?
Yes.
Core?
Yes.
Harris?
Yes.
Lust?
Yes.
Sunderman?
Yes.
Washington?
Yes.
Weber?
Yes.
Shear?
Yes.
Hove?
No.
Motion carried 8-1. Okay, the next item is change of zone 16013 from AG Agricultural District to B2 Planned Neighborhood Business District, from AG Agricultural District to R1 Residential District, and from R1 Residential District to B2 Planned Neighborhood Business District on property generally located on the northeast corner of South 14th Street and Pine Lake Road. Staff recommendation is for conditional approval. Are there any ex parte communications to be disclosed on this application?
I see none other than the ones that are already mentioned. I'd entertain a motion.
Move approval. Sunderman.
Second, Weber.
Jerry, please call the vote.
Cornelius?
Yes.
Core?
Yes.
Harris?
Yes.
Lust?
Yes.
Sunderman?
Yes.
Washington?
Yes.
Weber?
Yes.
Shear?
Yes.
Hove?
No.
Motion carried 8-1. Okay, next item is item 6.3C, use permit number 16009 to allow up to 177,000 square feet of new commercial floor area, including a retail warehouse on motorized vehicle fuel facility on property generally located on the northeast corner of South 14th Street and Pine Lake Road. This is final action on this item unless appealed to the city clerk within 14 days. Staff recommendation is for conditional approval. Are there any ex parte communications to be disclosed on this application?
See none. I'd entertain a motion.
Move approval.
Second, Core.
Jerry, please call the vote.
Does that include the staff recommendations as memo changes?
Yes. Thank you, Steve.
Per staff recommendations. Approval per staff recommendations
Yes.
of a memo number 4.
Number 3.
Or number 3, okay, thank you. Moved by Cornelius, seconded by Core.
Call the vote, please.
Okay. Cornelius?
Yes.
Core?
Yes.
Harris?
Yes.
Lust?
No.
Sunderman?
Yes.
Washington?
Yes.
Weber?
Yes.
Shear?
Yes.
Hove?
No.
Motion carried 7-2.
At this time, anyone wishing to speak on an item not on the agenda may do so. We're adjourned.